economy, and I'm sure you're probably a lawyer like most of us are, or a creator, or a businessman or lady in the entertainment industry. This is where you should be. Now, last year we had probably a smaller hall than this, but this year we're in a bigger place. And African art, African creation is also not where it was last year. For that to continue to work, we need lawyers who can connect, stand at the intersection of creativity and commerce. Because, art without money is just a hobby, right? Art with money is now business. That's where lawyers stand. And all parties can walk away feeling happy that they all got what they wanted, or at least the deal went better than it would have if it had gone beyond arbitration. So we're going to have arbitration today. We're also going to have debates. Is AI dangerous, or is AI assisting us, right? What do you think? Is AI helping, or is AI? It's helping us. Well, she thinks it's helping us. I mean, I think that one day my phone is just going to wake up at night and it's going to turn off my lights and probably electrocute me with the way AI is going if I annoy it. Do you think that's possible? Do you think that's possible? You think it's possible? I think my phone will wake up, turn off the lights, and then executes me one day because it hears everything I talk about. I talk about, popcorn, and next thing I'm seeing vanilla, chocolate, different types. But hopefully that doesn't happen. We're also going to have really serious conversation on cross-border deals. We're going to have conversation, how to seal these, how to put money in your pocket. So if you're here and you love money, let me hear you say, yeah, yeah. If you love money, let me hear you say, yeah, yeah. I love money. So if you want to put money in your pocket, understand the supply chain of the creative industry, we're also going to be having conversations that you find really interesting. So you're welcome again to the Global Creative Legal Summit. If you have someone who is on their way, tell them the summit is about to begin and they should be here. They shouldn't miss out on anything that is happening today, because I know today we're going to have really good conversations, and walking out of here, you're going to walk out a more insightful person, a more business-savvy person, and you're going to African creativity and African business. Once again, put your hands together for yourselves. One more time, put your hands together for yourself. So, we're going to be calling up someone to open the event. Think about someone who has had, global experience from Lagos to Washington to Paris. Someone who has closed deals, in amounts you probably haven't thought about yet. Someone with a global perspective, but with local impact as well. Please put your hands together for the convener of the Global Creative Legal Summit, Foza Oyinkansola Fawemi. Please, you can do better than that. Put your hands together for her.
Hi, guys. So I was going to be very formal and work, but then I realized that formality is not my strongest suit. Hi, everybody. Welcome, everybody. My name is Foza Fawemi, and I am the convener of the Global Creative Legal Summit, and I'm also the founder of Zeta Oracle. And it's very, 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 very nice to see everybody here today. Please give yourself a round of applause. So I'm going to try and read something now, because they say that I'm always very not formal. I lie. Anyways, thank you, everybody, for being here today. Distinguished guests, my beautiful law students. I see my law students from Babcock. I'm an alumni of Babcock, and they came all the way from Ogun State for this. I see my distinguished colleagues. I have people that flew in 10,000 miles to come and support this event. I see my litigation partner that left everything she's doing and all the people she's suing this week to come and attend this event. I see my beautiful colleagues at the bar that volunteered their time to participate in the mock arbitration. I see my associates that I disturbed their life in the last 2 months to put together this event. And I'm saying thank you to everybody. I'm saying thank you to my sponsors. I'm saying thank you to the Africa Creative Market for making this happen. Last year, we gathered at in the same hall last year at the same time. And it was the first time ever that we focused and shone light on the lawyers that worked in the creative economy. And when I gave my opening address last year, I was specific. I said, my mission is to platform the next set of Avengers that are going to fix the creative economy. And in the last 1 year, we've done that. The event last year showed us so many brilliant young creative economy lawyers, and also saw an interaction between the old and the new. And one of the biggest things that we picked from last year was that dispute resolution was a huge problem in the industry. Most people they were shying away from it, and what that led to is we lacked precedence in the entertainment industry. And you would agree with me that for us to grow as an industry, we need foundations and precedents for us to be able to refer to, so that investors that come into the economy are very confident that their investments are safe. And from that signal, and trust me, last year we had the legal aid where we spoke to about 200 creatives, and this was the same problem. Oh, somebody used my work, but I left it to God. Somebody used my photo, but I left it to Amadioha. Have they done anything since then? No, they are still here today, right? But the lawyers are were the Avengers, and were the replica of the angels in heaven, or whatever you believe in, to make sure that justice is served. And I thought to myself, I said, because GCLS is a very progressive conference. We don't want it to be repetitive. We don't want it to be the same thing. You come, you talk, you go. Every year we add new elements from the learnings that we learn each year. And this year we introduced the mock arbitration. The context of this is that for us to grow a connected market, investors need to be safe and feel safe that their rights are going to be protected, enforced, and properly monetized. Now, the court system takes too long. The entertainment system doesn't have that time. So what we are showing to you today is is an arbitration system, which is an alternative dispute resolution. It is faster than your regular court system, and is also more efficient. This today, on stage today, you're going to see very, very brilliant young lawyers approaching disputes from a very technical point of view, engaging in intellectual conversations, and also an arbitrator that is well-versed and experienced in giving you a perspective to how this is done. It's been a labor of love putting it together, and I'm very, very honored that everybody honored my invitation to come here today. And I hope we enjoy ourselves, and I hope that this is educative, and you also enjoy yourself. Once again, lawyers are not boring. Lawyers are quite cool. We have very, very cool lifestyles, as you can see with the way I dressed, but this is not how I go to court. But, but please pick something today, learn, make sure that it is very beneficial to you. If you see the participants around, ask questions, let's engage. And yeah, I declared the Global Creative Legal Summit 2025 open. Thank you very much, guys.
Creative economy, she's also contributing to the next generation of the backbone of the industry. She said something about, people getting into situations where their works are utilized by other people, and then they say, oh, I leave it to God. But the thing is, when you're creating anything, the reason why it's important that you benefit from it is, for creatives, there's no such thing as a retirement plan, right? You're not a normal person who works at the office and, after some years, you've had money piled up somewhere. The type of structure you have for your business is going to determine greatly if you're a well-fed person tomorrow or you're somebody who is forgotten while your money is piled up somewhere. We're heading into the next session, which is going to be a simulation of an arbitration. And ADR, alternative dispute resolution, is critical in the entertainment industry. First is, you don't have a lot of time to use in court. You don't have 20 years, 30 years to spend trying to get the court to declare that, somebody is supposed to give you money. The best way to resolve disputes in the entertainment industry is having them resolved outside of the court. So there will be a lot to learn from this session, and don't forget, take your pen, take your paper, and note down things that could help you in your own practice. If you're a lawyer here, you're definitely going to get a tip or two that will help you in drafting that dispute resolution clause, or in helping that creative that you're working with and finding a way to getting things solved quicker and faster. Please join me as I welcome Foza back on stage. We're getting into the next session. Please put your hands together for Foza one more time.
Damn, don't get bored of me, don't get bored of me. But you should clap. All right, so I'm going to introduce the coordinator of the mock arbitration for 2025. The hope is that we're going to do this every year. So if you didn't get to participate this year, next year is available for you. So I'm going to invite on stage, and I'm going to read her bio. Ms. Tokwe Tokonlawa is a dual qualified lawyer, Texas and Nigeria, and a partner at OTL Law, a boutique law firm in Lagos. With over a decade of cross-border legal experience, she advises and represents clients in arbitration, litigation, with a strong focus on intellectual property, entertainment, and commercial disputes. She's acted for high-profile clients in protecting copyrights in art, music, and compositions, and continues to work at the intersection of law and creativity. In 2024, Ms. Tokwe coordinated with us the legal aid for creative initiatives at the inaugural Global Creative Legal Summit, and also spoke as a panelist on resolving disputes and protecting creativity, and effective strategies for conflict management in the Nigerian entertainment industry. Beyond commercial practice, Tokwe is also very, very committed to social impact. She chairs the Token Foundation, which provides educational and financial support to vulnerable children, and Child Rights and Juvenile Justice Center, which offers pro bono legal representations to children. Let's give a round of applause to our coordinator, Adeforola Olutokwe Tokonlawa. Please keep it going, guys. Don't let them think we're boring. They will ban us. I fought so hard. I said lawyers are very interesting people. Thank you very much.
Thank you. Good morning, everyone. Good morning, everyone, and thank you for being here bright and early. We've been told that this is the highlight of today, which is the mock arbitration. So again, I want to say welcome to the Global Creative Legal Summit. And what is a legal summit without a segment on dispute resolution? Or is there a legal summit without a segment on dispute resolution? All right, so again, alternative dispute resolution. I think we've all heard of alternatives to dispute resolution, and what we mean is alternatives to court litigation. So we have our good faith negotiations. What else? Mediation, arbitration, adjudication. And here we're going to show you a segment on arbitration so you can get a real life experience of what an arbitration proceeding would look like. Again, we may have had experiences with litigation where you sit in courts, adjournments after adjournments, you sit all day, barely anything happens, you're asked to come back in 3 months, in 4 months, and after a long process, 3 years, 4 years, 10 years, you get a judgment that you don't even know how you're going to use it because the reason that you needed it for has already lapsed. And this is why we're here trying to tell you that there are alternatives to this. You by agreements. So when you're creative, you have your agreements. You can call your lawyer and say, look, my contract does not say anything about negotiation. It doesn't say anything about arbitration. So let them know that, look, I don't want to be sitting in courts. I want a quicker way. And these options are there for you. Negotiations, mediation, and even arbitration. And so without further ado, I'll be inviting the experienced team of lawyers that will be undertaking the mock arbitration today. we're calling the case in the arbitration between Ingrid Phillips and Big Movement Records. And so first, I'll be calling the claimant's team of lawyers and the party, Ingrid Phillips. Please come on stage. They will introduce themselves on stage. All right, thank you so much. So next, I'll be inviting the respondents team with the counsel and the party. Please, a round of applause for them, please. Thank you. All right, and then finally, if we don't know, so in arbitration, like a judge, we have a person called the arbitrator. And they typically are part of, they call the team of arbitrators or the people that work with arbitrators a tribunal. So it's not a judge, it's an arbitrator. And in arbitration, you can have one, you can have five, you can have three, depending on how complex the issues in the dispute is. So here in this scenario, we have a sole arbitrator who is supported by a tribunal secretary. So I would like to invite on stage our sole arbitrator, Mrs. Perenami Momodu. And then supporting her is her tribunal secretary, Esosa Osagi, an associate at OTL Law. All right, so before I hand over to Mrs. Mamodu, who is the sole arbitrator, I'll quickly read her profile and then I'll hand the mic over to her. All right, so Perenami is a consultant within Gately PLC's International Arbitration Group, where she's also the head of Gately Africa Practice. Before Gately, she was a partner at Alex, which is a firm in Nigeria and Ghana. She has over 14 years of experience in cross-border, complex, high-stakes arbitration and litigation within West Africa. She represents clients in arbitrations in sectors such as energy, manufacturing, retail, maritime, infrastructure, and foreign investments under the international rules. She's currently handling complex arbitrations in Nigeria, Ghana, Uganda, Tanzania, and Kenya, arising out of related post-merger and acquisition transactions. She is ranked as a national leader in both litigation and arbitration by Who's Who Legal Nigeria. She also advises on insolvency-related disputes, and in 2019, she received a special recognition award from the Vice President of the Federal Republic of Nigeria for her involvement in the insolvency and business rescue reforms in Nigeria. She's a member of the Dispute Resolution and Thematic Areas of the Nigerian National Assembly Business Environment Roundtable. She's also a council member of the Nigerian Bar Association section of Business Law. She's also a representative of the ICC Africa chapter. So will this case rise to the challenge? So you're welcome to the mock arbitration. Thank you.
Good morning, ladies and gentlemen. Can you all hear me clearly? Okay. So welcome to today's proceedings. I'm your solo. My name is Perenami Momodu, and I have assisting me here, the Tribunal Secretary, Esosa, Ms. Esosa. So before we go on, can I have quick introductions of the claimant's team and the respondent's team? So, of course, we start with the claimant.
May the tribunal be pleased. Good morning, my lord.
I think you need to be a bit louder.
May this tribunal be pleased. Good morning. My name is Akpantaku Olubumi. I'm the lead counsel for this arbitration. With me is...
Good morning. My name is Bruno Ibebunam.
You need to be a bit more audible. Remember that the tribunal secretary is taking notes. So did you say your name is Miss Olubumi Akpata?
My name is Miss Olubumi Akpantaku. It's spelled A-P-A-N-T-A-K-U. Miss. May the tribunal be pleased.
You are leading the claimant's team.
Lead counsel.
Good morning. My name is Bruno Ibebunam. I don't know if I need to spell that.
Just a moment. Talk by. I think the audio is not clear at all. I wonder if people in the audience can hear. Record her as been present.
As co-present.
So, respondents team, over to you. Can I have introductions?
Respectfully, Honorable Tribunal, I am Okenna Onyelu. Okenna spelled O-K-E-N-N-A. Onyelu spelled O-N-Y-E-L-U. Yes, and with me and my colleagues will introduce themselves.
Good morning, Honorable Tribunal. My name is Bakari Rukaya.
5 minutes each from each side to give opening submissions. Ms. Asosa is here. She's going to be taking note of the time. So please, we're going to taking note of the time. So please, we're going to be very strict with our time. So the opening submissions are really for you to. I'm sure you all know what opening submissions are. To explain, we're going to have 5 minutes each again of closing submissions. And the reason why we're having closing submissions is so that you both, or both sides, can address the tribunal after having heard or having listened to evidence on the key issues that the tribunal should be focusing on in terms of delivering its final award. Now, notwithstanding that the tribunal does have a right to put questions to parties, either during your opening submissions or your closing submissions, the tribunal also may put questions to witnesses during cross-examination or after cross-examination, but this will not impact on your timing. We will ensure that the timer is stopped at that time, so it doesn't eat into your 30 minutes or 5 minutes or whatever it is. So that's what the agenda for today is going to be like. Now, if there are no issues from any parties or if there are no housekeeping issues for us to address, I would like to go straight into opening submissions. I see your hand up, Mr. Onyelu. Yeah, go ahead.
Yes, respectfully, Honorable Tribunal, the respondent has a few concerns and little objections. We'd like to know if you would like to take them now or refer to our address.
What is the nature of your objections?
The nature of our objection is the fact that we received some processes late and we were not given the opportunity to respond to them, in the sense that our processes did not envisage that we're going to receive those processes.
What did you receive?
The exhibits, their amended memorial, and their witness statements.
Okay.
They were filed out of time, and we were not given an opportunity to, or we did not have an opportunity to consider them in our address, to consider them in our processes as well.
Okay. So you received the respondent's witness statement, amended witness statement?
Amended memorial.
Amended memorial?
Yes.
Mm-hmm.
And their witness statements and exhibits.
Okay.
Which they filed all of this out
When
of
did
the
you
time.
receive them?
Yesterday.
Yesterday. Okay. Claimant's team, what do you say to that?
In response to that, our memorial was not amended. However, when we initially served within the time, we erroneously served an unsigned memorial. So later we just resend the signed copy and subject to the approval of the team and of the tribunal. Then as for the exhibit, we just, for the purpose of this adoption of our witness, we produced our point of claim that we originally served them. So that's the issue.
So there's no new document. Your point is that there's no new documents that you've just served them.
No new documents.
What you served was a signed document as at yesterday.
As at yesterday.
And you re-forwarded or you resent your point of claim?
No, the point of claim was made into the witness statement for adoption for time purpose. That's
Okay.
all. No new document.
So, haven't heard from her and you haven't received it. Is there anything materially different from what you initially had and what they served yesterday?
We know that the verdict of this honorable tribunal will be made based on the documents and processes before it, and we already took notice of the fact that there were no exhibits to substantiate their claims, and the fact that their memorial was not signed obviously makes it a plethora of authorities that suggest that unsigned documents cannot be relied on, and we had considered all of that in our processes, knowing that the final decision will be made based on what's before this honorable tribunal. And if the exhibits are coming much later, then I think we should have had the opportunity to then amend our own arguments to address the exhibits. So I think the fact that the respondent was not given this opportunity puts it on my client on a thin edge. And I know if this honorable tribunal would permit me to point its attention to the Arbitration and Mediation Act, which gives you the power to determine the admissibility, relevance, materiality, and weight of any evidence. So our general objection is for this tribunal to consider the weight that it attaches to these documents, exhibits, and these processes in this matter.
To that document or the relevance of that document. Now, I say that because in arbitration, the rules of evidence will typically not apply in arbitration. Now, I will not shut my eyes to documents that have come in, even if they've just come in a second ago, right? But you do have your recourse in terms of addressing the tribunal, as you've said, on the relevance, materiality, the weight to be attached to that document. So what I would expect from you is, at the stage of your closing submissions, after evidence has gone in, because it's going to go in, after evidence has gone in, you can then determine, right, and address me to say, look, they've put in exhibits X, Y, Z, and you do not think that any material weight or the tribunal should pay any relevance to that document because X, Y, Z. Understood? So, but in terms of those kind of objections, and it's good that you've mentioned it, I do take note of it. But let's be clear in the hearing today, the rules of evidence do not typically apply in arbitration. And so we will not be taking unnecessary objections. You're free to object, but note that I will not delay proceedings on account of those kind of issues. That's one. So, but do take note for your final submissions about any documents you want to bring to my attention and about the materiality and the weight and the relevance of such documents to the determination of the final issues hearing. Now, having said that, I think we can proceed. Now, again, another point you need to note that if there's any prejudice that you have suffered on account of any document that was forwarded yesterday or whenever, you can address me on that on a cost issue. Whatever prejudice you have suffered, consider if your prejudice can be suffered can be cured by an award of cost. It may not, it may, but do consider that and address me on that at a relevant stage. So if there are no other housekeeping issues, can we proceed? Claimants, can we proceed if there are no housekeeping? Respondent, are you fine to proceed? Okay. Okay, so Ms. Apantaku, we're going to have your 5 minutes opening submissions. Like, you know, we've read, everyone, we know your case, we've read your case.
From unjust and unconscionable exploitation at their vulnerable state of mind and legal capacity. The claimant, Ingrid Phillips, is a victim of an unjust and exploitative contract at the age of 16 years old when she was a minor. Our Nigerian laws, both our child rights law of Lagos State and common laws that bind contracts in Nigeria, is deliberate and protective of a child's contractual legal capacity. The law is very clear that ordinarily a child contract cannot be made to be enforceable, especially contract of commercial exploitation, except they are for necessities or beneficial services. Beyond that, where a contract execution is subject to a condition of performing a specific obligation or the happening or doing of an event, such contract cannot be said to be completed or valid until such condition is fulfilled. The intention of the law is simple: to shield minors from improvident bargains until they have the maturity and capacity to freely enter into such contracts. We are here before this tribunal to show the court, to show this tribunal that the recording agreement being the subject of this arbitration is the very opposite of being a beneficial contract to the claimant, and should not even be regarded as a valid contract to start with, or form the basis on which the respondent's claims of rights would rest. This is a contract that styled a 16-year-old into a 7-year exclusive contract, stripped her of our ownership to our creations and performance in perpetuity, classified our works as of work for hire, and assigned all of our copyrights exclusively to the respondent, all for the bare minimum compensation, without any independent legal advice for the minor, nor parental consent, despite the agreement itself requesting for such consent. The realities of this case will show you that the respondent knew, as a fact, the safeguard for minor contracts is very important, but chose to proceed without it anyway, just to make the claimant of our economic potentials and benefits. They will have you believe that in the benefits of promised allowances and advances, but structured each one of them to be suffocatingly recouped from the claimant's future royalties. But we are here to prove that the trust and investment accounts they now rely on were not acts of generosity, but commercial mechanisms to secure their own benefit while exploiting the creativity of a child. And the claimant has validly repudiated the said contract, even in events where such contracts can be considered to be existing. The law of Nigeria is clear and has no room for such contracts to stand, and we are praying this tribunal to also not allow it to stand. Ratification after majority requires a fresh, intentional contract, not mere continuation or passive acceptance of royalties. The fact that
protect the sanctity of commercial agreements in the Nigerian creative space. We are here today to show that the contract between Ingrid and BM Records was valid, that the contract between Ingrid and BM Records is enforceable, that the contract was ratified, and the repudiation is unlawful, invalid, and non-efficacious. We're also here to show this honorable tribunal that the claimant has infringed on the intellectual property rights of the defendant, BM Records, and has also breached the recording agreement with BM Records. And to do this, we will be calling on a sole witness, whom through we will tender all our exhibits to try and convince this honorable tribunal that to grant our reliefs in our counterclaim and hold that the claimants are not entitled to any of their reliefs in their points of claim. Thank you.
Thank you. Thank you.
Here today
Will be the truth
will be the truth
and nothing but the truth.
and nothing but the truth.
Okay. Thank you. So I will hand you over to your lawyers.
Thank you, Honorable Tribunal. Igor Phillips, can you tell this honorable court your name, your address, and what you do?
Mr. Pantako, you have just 1 minute to do the exam in chief and just to adopt the witness statements, because we
just to be clear, you said something earlier that the statement is already deemed adopted.
Yes. So whatever it is you're doing, you have 1 minute to finish and hand her over.
Ms. Ingrid, your statement is already deemed adopted before this tribunal.
Okay.
I'm going to refer you to your paragraph 5 of your statement on oath before this tribunal. You mentioned a particular contract, recording contract dated 15th of April 2020 as Annex A in your statement. If you see the contract, can you recognize it?
Yes, I can.
Can I show her the contract for her to identify?
So just to be clear, in arbitration, before we get to the hearing stage, a hearing bundle would have already been prepared.
Okay.
And I've got a hearing bundle here with all the documents. So we do not need to go into each and every document you have tendered in your witness statement and to mark it as exhibits, whatever it is, right? So if documents have already been referred to in your witness statement, the presumption is that all the documents are in the hearing bundle. You understand what I mean? So we don't need to go over it one after the other and tender it and accept it. Remember that I'd made a point earlier to say that the Evidence Act does not apply to arbitration. So those rules of evidence do not typically apply. As long as the documents have been submitted and they've been included in the hearing bundle before the tribunal, they're all deemed admissible. Understood? So the point is, there's no need to go over those documents one after the other. If you want to refer her to that document for a specific purpose, you can do that. But it's not for me to mark it and tender it and all that now.
Thank you, Honorable Tribunal. Your statement and all the annexures are already before the tribunal as deemed adopted. Would you tell the court what you want the court to do for you?
I would like the court to adopt my statement as evidence in chief. I would like the court to adopt my witness statement as evidence in chief. And also for the court to grant relief to my prayers. Thank you.
Right. That will be all for our examination.
Thank you. Respondents team, over to you for cross.
Honorable Tribunal, I defer cross-examination to my colleague, Franklin.
Okay. You've got 30 minutes for your entire cross-examination in today's proceedings. So if they're presenting 2 witnesses, you've got 30 minutes to handle both witnesses within that time.
Thank you, Ingrid, for appearing here today. We just have a few questions so that we can get to the end of this matter. So the questions are very direct and we'll need you to provide just a yes and no to most of the questions here. The first one is, would you agree that the record label launched a merchandise line and even opened a trust account in your name, correct?
Correct.
And you are aware that the trust contained funds set aside for your benefit, right?
Correct.
The name, you never wrote to the record label rejecting the trust or merchandise, did you?
Could you come again?
You never wrote to the firm, to the record label rejecting the merchandise line launched in your name and also the trust account opened in your name.
Correct.
The record label invested a lot in releasing and promoting your album, launching and promoting your merchandise line, and at the same time made a lot of investments, right?
Correct.
You attended concerts and events and endorsed products in line with your agreement, correct?
Correct.
So you agree with everyone here that your decision to repudiate the contract only came after your fame and income increased, is that right? So you can agree that your intention to repudiate the contract came after you made your name and your income increased, right?
No, it did not.
Okay, we're still coming. You acknowledge that the record label took financial risk in investing in your career by investing in your albums, promoting your albums, releasing your albums. You knew the record label took financial risk in doing that. right? You
Sorry,
benefited.
please.
Ms. Phillips, you will need to, you know, we can't record nodding, so you will actually need to speak.
Yes, correct.
It is true that your attempt to repudiate this contract leaves the record label exposed to losses after years of investment.
Incorrect.
Why do you believe so?
Before I answer, I need to get your question properly. Could you come again?
The record label invested a lot in releasing your album and also promoting your album. The record label took a lot of financial risks, yes or no?
Correct. However,
Yes or no, please?
no.
Sorry, Honorable Tribunal, I would like to implore the claimant counsel to not tell the witness what to say. I believe we're here in the interest of justice, and if the claimant counsel repeatedly nods and tells her clients what to say, then I'm guessing we should not be here.
Wait, I want to respond. I don't know if I can respond to that.
Please do.
So the claimant, the witness, is currently properly not even facing the claimant's team. So I don't know how the respondent team will be alleging that we are feeding the claimant. I also want to avert the minds of the respondent team that this is an arbitration. We are here to achieve a win-win situation. We are not here for a win-lose situation. I wanted to point that out when the preliminary objections were coming, that the essence of this arbitration is to reach a very favorable, outcome. And if the respondents team are not willing to participate in this process, then the claimants team will wonder why we are here in the first place. So we should avert our minds to that fact, and I think that will help the whole process more as to the objections. And we are not here to fight. We are here to get an amicable outcome. So I just wanted to point that out as well. Thank you.
Ms. Phillips, I think what may help is, because really, ordinarily you should be facing the tribunal. It's just because of the kind of setting we're in. And to be honest, I don't know what you mean by them telling her the answers. You know, she's backing them really. I don't know what you saw, but I think we can make headway if we... Can you turn your seat a bit? Without backing the audience. Yeah. Let's see. Okay. I think that this may give them a bit more comfort.
Yes, we're grateful. We're grateful.
All right, so let's go ahead, please.
Ms. Ingrid, are you ready to continue?
Yes, I am.
Okay. From the contract which I believe you have seen, is there anything that the record label has not complied to so far?
They have complied, however...
Please, I want you to be direct. Is there anything they have not complied to?
Madam Arbitrator, I have a question. If there are explanations to these direct questions, am I not permitted to explain?
You are permitted to explain, right? No. In this hearing, we're here to hear from the witness. Do you understand what I'm saying? We're here to reach a resolution. We're not here to ambush a witness. So if a witness has an explanation to make, believe me, I'm going to ask her to make that explanation. If I do not think that that explanation is necessary, meaning I've gotten the information I want and I don't think it's necessary, I will make that clarification. And also to the claimant's team, to be clear, just because I said the rules of evidence don't apply does not mean that you cannot object. You can make objections, although you can only make reasonable objections. I will not allow interferences in today's proceedings. So I think we should have those ground rules. I want to hear from the witness because I want to hear exactly what has happened in this case to determine how we're going to rule or how to reach a proper resolution of the issues. So if I do think that she needs an explanation, or if she needs to speak, I will let her. But of course, as they say, the sky can't be the limit for cross-examination. I will allow you cross-examine. So. But if you do need to make an explanation, and I think it's necessary, try to make it, and we'll see how that goes.
Okay. Our question stands: has the record label done anything outside of the scope of this contract? Have they complied with each and every term of this contract so far?
The record label, when they approached me, they told me they were going to give me some benefits, the 50,000, and they were going to make me a superstar. However, while complying to this, my education was very highly affected. So in the course of carrying out their duties, it still affected me.
Thank you for your compassionate appeal. But it is important to state here, and which you have also agreed, is that the record label has actually complied with every term in this contract so far. But you can also remember that one of the terms in the contract is that you have entered into an exclusive relationship with this record label, and you on your own has solitarily, have unilaterally licensed a song, an album which was released by the record label to a third party. Would you say that was part of the terms of the contract?
When I was signing into the record label, I never had a legal opinion. However, when I became of age, I decided to seek a legal opinion, just an opinion, nothing more. And from the opinion of my lawyers, they told me that I could repudiate once I attained majority, which wasn't something the record told me as at signing the contract.
Thank you. This was not really connected to the question I asked. Because the question I asked was, you unilaterally licensed an album released by the firm to a third party. I believe by then, you are still below the age of 18, according to you, right?
At the time Gyration gained traction, I was already 19, and I sought legal opinion.
And the legal opinions told you that you can unilaterally license the song to a third party without even speaking to the party that you are contracted to in the first place. Thank you for that. I suggest you seek better legal opinion next time. Thank you.
Do you have any re-examination?
Yes, ma'am. Yes, the arbitrator will do. Witness, you were...
Apply that the witness should face us.
No.
It's an examination.
Witness, you were just asked the question that whether you never rejected any merchandise or trust account, and you said no. At what point were your merchandise and trust account released to you?
Attaining the age of majority.
In the meantime, who was managing this trust account and merchandise?
BM Records.
BM Records. Are you also aware that BM Records was your manager and they handle all your assets and properties, money during the time?
They handled every single
During the
thing.
contract or after the contract? After you attained majority, rather?
During the contract.
Sorry, let me rephrase that.
Okay.
Did BM manage your assets, your account, and merchandise properties, or whatever it is, merchandise account, after you attained the age of 18?
Yes, they still did.
You also just mentioned before this tribunal that the investment they made was to your benefit, and you never... What was the question?
Honorable Tribunal. Honorable Tribunal.
Yes?
Yeah. We believe the witness statement on oath is before you, and the claimant seems to be examining the witness all over again. I believe all these facts are before you, and if there are no contradictions...
Can you allow them re-examine the witness? She hadn't even asked the question. I was still waiting for her to ask the question. Can she finish asking the question?
No. Yes, Honorable Tribunal.
Can we proceed on that basis, please? Respondent's team. Thank you very much. So, Clement. Yeah. You were still in the middle of asking the question,
yes,
except I'm mistaken.
So these investments and benefits, were they free of charge, or have they been recouped? Were they given to you free of charge, or were they recouped by the record label?
They weren't given to me free of charge. They were all recoupable.
That would be all.
Okay, thank you. There's a question I have for you, and I'm a bit curious. In terms of the... In terms of there's an allegation of a breach from the respondent side in terms of a copyright. When did you enter into that relationship?
The agreement, my contractual agreement with them.
Not the one with not the one with the respondent.
The one gyration.
Yes.
In 2023.
And how old were you at the time?
I was 19.
You were 19 at the time of the contract pertaining to gyration?
Yes.
Okay. Okay, I have no other question for you. May you what? Yeah, but I asked her and she's answered. So you want to testify for your witness?
No, I will address it in the address.
Exactly. Okay. So I think Miss Phillips is discharged. Thank you, Miss Phillips. Enjoy the rest of your day.
Gyration license was 2025.
Okay. Do you have any other witness, claimant?
Yes, we do, madam. Mrs. Ngozi Phillips.
Good morning, Madam Arbitrator.
Good morning, Mrs. Phillips. Nice of you to join us today.
Thank you.
So we're going to take, I'm going to ask Esosa to affirm you very quickly.
Okay, so you're just going to say after me. I,
Mrs. Ngozi Phillips,
hereby affirm
hereby affirm
that
I, Mrs. Ngozi Phillips, hereby affirm
that everything I say
here
will be nothing but the truth.
Will be nothing but the truth.
Will be the truth and
Will
nothing
be
but
the truth and
nothing but
the truth.
Thank you.
Thank you.
You're taking her now.
Ms. Apantako, over to you.
Thank you, Arbitrator. Mrs. Ngozi Phillips, your statement on oath is then adopted before this tribunal. You can continue.
Okay. So over to...
Sorry, we're just talking to each other. We still have like questions for her.
What question?
As to if benefits were acted under the testimony.
She has been then adopted.
Okay, no problem.
Hello, you can continue.
Okay. So claimant's team, all good? Yes. So respondent, over to you for cross-examination. You used 9 minutes for your first cross, so you still have about 21 minutes.
Welcome, Mrs. Philip.
Thank you.
When did you become aware of the existence of the relationship between BM Record Label and also your daughter?
Few days after she had already signed the contract on the 15th of April 2020.
So we can say that within reasonable time you became aware of this relationship.
Yes, and I visited the respondent.
Don't worry about that. So you became aware of this existing relationship between your daughter and this record label?
Yes.
And you're also aware that your daughter was financially and otherwise benefiting from this contract, yes?
No.
You were not aware?
I was not involved in any negotiation, no contract between both of them.
So when you knew that there was a relationship between your daughter and this record label, you did not intend to ask anybody?
I did. That's what I was about to say.
So when you asked, you were not informed that there were financial benefits attached to it?
No, I was just told that they would train her and make her a star.
So that only that was enough for you, right?
Yes.
Did they not
I
make her
also
a star?
asked for the agreement that she signed, but I was not let to see. They just told me that they were going to train her and that she was going to become a superstar. At the end of the day, I'm semi-literate.
At the end of the day, you are a semi-illiterate.
I'm semi-literate, yes.
So couldn't have relied on you to actually understand the terms of the contract in the first place?
Yes, but if I knew the nature of the contract, I could have sought independent legal advice.
But you are semi-illiterate. How can you understand the terms of the contract? These are quite technical intellectual property terms.
Someone can explain it to me, no?
Who is going to explain it to you?
If you entered into a contract with my daughter, you are supposed to explain the terms of the contract to me.
So at the end of the day, you are still going to rely on us to take care of you, right?
If you had explained the nature...
Objection, Honorable Tribunal. The claimant team is wondering if the respondent team is, now arguing with the witness or putting questions. They are literally badgering the witness, and we just wanted to bring that to the attention of...
Thank you, Honorable Tribunal. I believe what we are here is to put questions to the witness, and we are doing exactly that.
The last question that you asked, can you rephrase that? Because the last question that I heard you say was, so you're relying on us to take care of you.
Yes.
To be honest, I didn't understand that question.
I was asking
so
that...
perhaps rephrase that question so that she understands it. It goes on the record of exactly your intention in terms of that question is then able to be captured on record.
Okay. From what you said, you are semi-illiterate and you will not be able to understand the terms of the contract.
Yes.
And you rely on us to explain to you the terms of the contract, right?
I was given an explanation when I came to visit the firm, and I was told the benefits solely of that contract. I never saw the contract. I was only told that my daughter would be trained and that she would become a star.
And I'm asking you right now, will you say that the record label met the end of the bargain, which is making your daughter a star?
She already had national success at the age of 15, so she was already actually a star.
So if you believe your daughter was already a star, why do you agree to us making her a star?
Because I think that every mother wants the best for their child, and she was already excited about the contract she entered into with
So we can say that within reasonable time, you were aware of what this contract entails, and we lived up to the end of our own bargain, but you did not. And here you are coming here to repudiate the contract.
I was never aware of what the terms of the contract entailed.
Honorable Tribunal, sir. Honorable Tribunal, sir. We will be objecting to the last question. That was an opinion question, not a direct question to the facts of this case. That was an opinion, asking for the opinion of the witness. We will be objecting to that last question.
Honorable Tribunal, we would like to remind the claimants that the rules of evidence do not apply in this proceeding. So the idea of her giving an opinion should be allowed. That's our view.
To be honest, I didn't think it was an opinion. But let him go ahead. It seemed to me like she was supposed to be the guardian of the claimant at the time, and he was asking her, as far as I understand the question, direct issues pertaining to that period. So I think you should go ahead with that question. Of course, if you frame it as an opinion, you already know I probably will not allow it. But please go ahead.
Thank you. You stated before your daughter was already a star, right?
Sir?
You stated earlier that your daughter was already a star, right?
Yes.
And you came to us and we told you that your daughter is going to be a star.
And that you were going to train her singing career.
And you still accepted. So you accepted that we are going to do what your daughter was already, which is a star. And you still accepted. Why, knowing that we will not be doing anything? Because practically we will not be doing anything, and you still accepted that, right?
No, I knew my daughter was a star, and I know that she can get better. That's why I said, you guys explained to me that you will be training her to become better than she already is.
So, to put it much better for you, you wanted us to make your daughter a bigger star, right?
Yes.
Will you agree that we made your daughter a bigger star?
Not exactly. I was not satisfied with the schedule that my daughter was facing because she barely attended schools. She missed a whole session of school after I had already paid for it, and I got no refund for that. So I feel like it was mostly detrimental to her. She had no friends at the end of the day. So, and I never received any money. I never heard of any money coming truly into
I believe my question was clear. do you think we made her a bigger star? And you started referring to the fact that she didn't attend school and all of that. I believe being a star doesn't concern all of that. But so far, you have actually stated, and you impliedly stated that we made your daughter a bigger star, which means we kept to the...
You cannot say what she impliedly stated. You understand what I mean? If what you're saying is an argument, you are now making an argument by saying a witness impliedly stated something. It's either she has expressly stated something or she has not stated it. So please, limit your questions to what she has stated.
Did you ever try to read the terms of the contract yourself?
Sorry?
Did you ever try to read the terms of the contract yourself?
When I came to visit the respondent, yes.
Thank you. But you stated earlier, I don't know whether you can remember, that you never saw the...
No.
And how is that...
No.
And how is that... Anyway, go ahead with your
I'm
re-exam.
driving at...
Yes.
I'm arriving somewhere. Are you into music contracts or are you in the industry?
No, not at all.
So do you have any idea or understanding as to how these contracts work?
No.
The intricacies of these contracts?
No, I don't.
So you stated here that you are semi-illiterate.
Yes.
You stated, please confirm if you read the contract, if you attempted at any point to read the contract.
No, I did not.
Okay, another question. Was your daughter well taken care of before the contract with the respondent?
Yes, she was very well taken care of.
So your daughter, please confirm again that she was well taken care of as to her necessaries, and you played your role and as the parent to the claimant.
Yes, I did.
Please, I want you to confirm or to state to this honorable tribunal if you obtained any benefits under this contract as the parent of the claimant.
No, I never did.
And how is that a fallout or a re-exam question? Was there any question that they had asked in their cross-examination that is warranting this line of questioning?
Yes.
Which question was that?
They asked certain questions to show that as the parent of the claimant, she obtained certain benefits under the contract. And the previous questions were as to her being aware of the contract and her reading the contract and understanding the intricacies of the contract. There were like certain different questions they asked.
To be very clear, we never asked any question pertaining to the fact that she benefited from this contract, because this contract was just for her daughter and the record label, and not just for her.
And that's the record, that's my record and my recollection. I didn't hear any questions here as to how she benefited directly from that contract.
I'm sorry, the tribunal. I think what my colleague was trying to infer was from the question when the respondent was asking the witness if the witness was relying on them to take care of her. I think that's where the inference
came in. But they clarified and they said was Mrs. Phillips relying on them to explain the terms of that contract to her. That's my understanding of that question.
That's where he is inferring whether they expected her to understand the intricacies of the contract ordinarily.
Okay, go ahead. You have just 1 more minute for re-examination.
I'm almost done, if not done. Yeah, so that's about it. Thank you very much.
Okay.
I'll be home, my lord.
Okay. And just one question from me, Mrs. Phillips. At what point exactly did you become aware of this contract that your daughter had entered into?
She informed me about a few days after she had signed the contract, about 4 days after she had signed the contract, and I also saw it on the news.
Okay, so when she was 16 was when she had informed you of this contract?
Yes.
Okay, thank you, Mrs. Phillips.
Thank you.
Honorable arbitrator, that will be all for our witnesses.
Okay. Thank you, everyone. Claimant's case is closed. You have no other witnesses. We will now ask the respondent to open their case. by calling, you only have one witness, correct?
Yes.
Yes, so please call your sole witness.
So, we have a sole witness, and just to remind this honorable tribunal that, like we said earlier, after the preliminary meeting, we were informed that we would not be filing witness statements on oath. But we, the respondents, were not further informed that we had to file. The claimants were informed, we weren't, so we did not file a witness statement on oath.
Okay.
So we'd just like to briefly allow our witness to give his testimony, and because we don't have a witness statement on oath, we were caught unawares in that sense on filing a statement on oath.
Okay, do you have any response to that?
We also like to register our disadvantage in this case, because we were told that in this case we are to rely on the fact that they have in their point of defense to prepare for this. So if there's going to be new evidence here, we also would be at disadvantage when we have to cross-examine the witness.
Okay. Can we take it? I mean, this would typically never happen. But can we take it that the same facts in your defense will be what will be in your witness statement? Respondent team?
Certainly, to an extent, but I would just like the tribunal to note again that we are at a huge disadvantage now, because we cannot, like we said, they had filed further processes and we were not given the opportunity to review what is in our points of defense and all. So, but we can rely on that, we can.
So, are there new facts that you would want to present to the tribunal through this witness?
There are not particularly any new facts, but I think we would have still reserved the right to go through our processes again in light of the new processes that we received. So I just want to put that on record. Not that we can rely, we'll definitely rely on it. I just want that to be on record.
Okay, so that we do not belabor the point.
Yeah.
And so we move on. Like I said, this will typically not happen in realistic circumstances. I think the best way forward is to have that your defense, and let's deem it as a witness statement. It's not a witness statement, we know that, but let's just so that we can move on. Deem it as a witness statement so that your witness does not have to come out and, and rehash the facts. Because that, I fear, may also present too much of it won't be too realistic if we have your witness come out to start saying this evidence, because it won't really happen in real life or in practice. Yeah. So let's move on that basis, please.
We can have him now. Yeah, you. Okay, no, sorry, Rukayat. I would like to defer to my colleague to
Okay.
Witness. Sorry.
And who are you calling up now?
Our witness.
What's his name?
Mr.
Israel, I know.
Mr. Israel, I know.
Okay.
Nice to have you here with us, Mr. Israel, I know. Good afternoon. Good morning.
Good afternoon.
I will hand you over to my colleague Esosa, who will affirm you quickly, just so that you know that you're on oath.
I, Israel, I know.
Hereby affirm
Hereby affirm
that everything I say here today
that everything I say here today
will be the truth
will be the truth
and nothing but the truth.
and nothing but the truth.
Thank you.
Okay. Just to quickly, have him explain his role for it to be on record, since we do not have a witness statement on it, I will ask him a few questions for that. Okay.
Proceed.
Thank you. Good day, Mr.
Good day.
Please, can you tell us where you work and what's your occupation and why you are here today?
So as I stated, my name is Israel, I know. I work at Big Movement Records Limited, and I am in charge of operations and artist development. So I'm the manager assigned to the claimants in this matter.
Okay. Are you aware of the contract between the claimants in this party and we, the respondents?
Yes, I'm aware of the contract.
Okay. And you are also aware that the claimant was a minor when this contract was signed?
Yes, I'm aware that she was 16 at the time of signing the contract with us.
Okay. Just to put it on record, for time's sake, are you aware of the reasonable measures the respondents, Big Movement's record, made in securing the benefits due to the claimant?
Yes, I'm aware that we created a trust account where we were depositing our royalties and other benefits she was getting from our contract. And I'm also aware that we managed it for her until she was 18, and since then she's had access to the trust account.
Okay. And so far, in relation to your dealings with both the artist and the respondents, the Big Movement, you can say that Big Movement record has kept to the end of the bargain in this contract?
Oh yes, we have kept everything stated in the contract. We have abided by it.
Okay. Are you also aware that the claimant kept to our own end of this contract?
Miss Ingrid, yes. I mean, we had a very
If you
good...
recall at the beginning, I had said we're going to take the defense. What I thought you were going to do with the question you wanted to ask was just to ask him the regular, what do you do, where do you live, you know, and all that. I don't think we should belabor that point,
Okay.
right? I don't think it's fair for you to start re-examining or to do a proper exam in chief in the manner in which you choose to do, after me having directed that the statement of defense will be deemed as his witness statement.
Okay, then we'll close that.
What you can take him to say is that, you know, you ask him to deem his defense as his witness statement and ask him what he wants from the tribunal, and we can take it from there.
What do you deem as your defense today, and what do you want the court to do with it, this honorable tribunal to do with you?
Okay, I would deem the point of defense as my testimony in this matter to be relied on. Okay,
No, he can't back that one, is the point. Talk by. So they said it's fine like that, okay.
Witness.
Yes.
Welcome.
Thank you.
At what age would you say you discovered the claimant before you signed her to your record label?
Please put a context in that question, please. At what stage?
At what age?
At what age?
Did you discover the claimant?
Before we signed that to our record label. Yes, we discovered that yes, she was already a musician and all of that, you know. But we discovered that sometimes around age 14, we watched her for a while. Then we felt like, we could invest in her to, you know, bring her up.
At what age?
At what age? Yeah, I said
what age?
At what age? Yes, around 14, thereabouts. You know, we had been scouting her, and we saw that she had a lot of potentials. We could invest in her.
So you're confirming that you signed the claimant when she was 14?
No. I said we discovered her at 14. We scouted her for a while. Then at 15, we felt like, we could, you know, invest in her and, you know, benefit from both sides.
So you're confirming that you signed her when she was a minor, to move on from that
Well,
person.
if 15 is minor, yes.
At the point you discovered her, would you consider her a rising star at that point?
Yes, of course. I consider her a rising star. That's why we invested. I mean, I wouldn't put my money in what won't bring back to me.
So she was already doing well for herself at the time you discovered her? Before you signed her?
I don't know. I was not there, so, yeah.
As an artist, she was already doing well, would you, in your opinion?
If you say so.
When you signed her, you gave her some benefits according to the contract. You said you're going to be giving her a monthly allowance of 50,000 naira, right? Is that correct?
Right.
You said you would pay for her educational and living expenses. Is that correct?
We said we'll pay her 50,000.
You would pay for her educational and living expenses.
Educational, I'm not sure about that, but yeah, other expenses.
That's what is included in your recording agreement that you signed with her.
Well, that's it.
Which are recoupable. Is that correct? You intend you recoup that?
Yeah.
You also mentioned some advances, that you give her advances, but you never mentioned the figure. Is that correct?
Okay, yes.
Which you also intend that you will recoup from our future royalties. Is that correct?
Okay, yes.
Witness, would you also confirm that this, the agreement you signed with her is an exclusive agreement for recording contracts, that she does not have the right to record with any other person without your permission?
Yeah, it's an exclusive contract, but no, I don't think it was stated that she cannot. When I say exclusive, it's not necessarily limited to recording, because when we say exclusive, okay, she's signed to us, we manage her, we invest in her. I think it was stated in the contract that we manage her performance, even release of albums and all of those things. So that's, yes, it covers those areas.
So you, in your contract, you initially signed up for recording services. That's what your contract said. And also in the same contract, you also went ahead to sign yourself as our exclusive manager. Is that correct? Managing all our other business recording services.
Merchandise, yeah.
I need you to confirm that you also, by the same contract, signed yourself, BM, as our exclusive manager for the entire period.
Yes, yes, and that's my role. That's why I was assigned to her, yes.
Sorry, hold on, I'm trying to. So for your exclusive management, you confirm that the label will undo all of our live performances, tours, endorsement deals, sponsorships, merchandising, and publicity campaign.
Yes.
All of it.
Correct.
Exclusively to BM.
Exclusively?
To BM.
To BM, yes. BM agreed to manage all that.
You also do you also agree that you also exclude her under this contract from having all sideman interactions with any other business?
By the contract, that she does not have any?
She does. Let me simplify it to you. Do you also agree by your with her, she does not have the right to work with any other person aside BM?
Yes,
for
I mean,
whatever purposes.
That's why we are putting money. If I'm putting money in you, I want to gain it. And that's why there's a term for the contract. It's not like it's for all of our life. So.
I'll get that. I'll get that. Now, you mentioned earlier that in fulfilling your obligations, you opened trust accounts for the claimant.
Yes, yes.
And that is where you deposited all your business dealings.
We deposited benefits from the contract,
From the
royalties.
All our royalties.
Yes.
Thank you. Now, from the trust account, you initially deposited an advance deposit of 5 million naira.
Okay, if that's the case.
If that is the case.
Yeah, I said that's the case because I am label manager. I'm not in charge of the finances.
So you're saying you don't know what is going on in your own company?
No, I'm saying I don't know what's going on with the particular money put in there. I mean, I don't calculate the interest or anything. Our manager is assigned. I'm in charge of our development or performances and all of that. And I'm aware that, yes, money is going into the trust account. But as to the figure, I cannot speak to that,
so
to the exact figures.
Thank you. So who authorizes whatever money goes to Ingrid in your company, if you're not aware of the finances?
That's the managing director, not me.
And who is the managing director?
That's Mr. Dari.
Oh, you're not Mr. Dari.
No, I stated earlier.
Yeah, it's not Mr. Dari.
Yes,
you're not the managing director.
No, I'm not.
So you're not the one that signed the claimant?
No, I work with them and I was assigned to her. That's what I said. I said I'm in charge of artist development.
So you're not aware of the fact as it relates to the claimant in this case? Is that what you're
No,
confirming?
I am the manager assigned to. I said I'm not aware of the figures. You said, oh, they transfer 5 million. Is that? I said, no, I don't know whether it's 5 million
As a
or 10
manager,
million or something.
are you saying you're not familiar with the business of the client that you're managing?
I am, but I am not familiar with the actual figures. I mean, I don't exactly deal with the actual figures. I don't
Witness,
have to deal
have
with
you
that.
seen the statement, the trust account statement of the claimant?
What I just, yeah, I've seen it, but what
As a
I
manager.
just need to know is that each party is doing what they are meant to do. Okay, I manage, do all of that, and then I know that, okay, company, have you done your part? You sent the money. Okay, that's it. I just know that, okay, there's a trust account, money is entering into it, and that's
Witness,
my
as a
duty.
manager, are you aware that your duty is to manage the business of the claimant as far as this contract is concerned?
So as I stated, I'm a labor manager as assigned by the company. So basically what I'm meant to do is to just ensure that the artist is developing, and which she has, I mean, as you will tell, and then she's fulfilling her terms of the contract. You release albums, you do all of that. So that's my duty.
Good. Part of your duty is to also know if the benefits that is accrued to the claimant is also given to her. Is that correct?
Yes, that she's receiving royalties and all of that. But if you still want to ask about the figures, no, I can't
I'm not
speak to
asking
that.
about the figure. I just want to be sure that as a manager, you actually know what is going on with her business.
With her, yes, I know what is going on.
If you don't know what is going on with her business, would you confirm if the 50,000 naira monthly allowances that is said to be paid to Ingrid is being given to her monthly?
Yes, I would say it's being given to her monthly, because typically what happens is whenever she has any grievances, she's meant to let me know. And at the time of the contract,
So how can you
now,
confirm that she's paid? To whose account do you pay to?
to whose account do I pay?
Do you
to?
pay the 50,000 naira you're giving to her?
The 50,000 naira. No, I think that's paid to her is the royalties and everything.
To a certain party. If he's not able to confirm it, it's a yes or a no to a certain party. If he's not able to confirm it, it's a yes or a no, it's a yes or no answer. So that objection is overruled. Let the witness respond, please.
Yes, I was going to say that I'm not able to confirm, just that I can't confirm the actual figure for the other 5 million.
Thank you, witness. So you just confirmed that you have no idea of whatever payment is made to the claimant under your management. Also, would you say that all the businesses that the claimant have done for the respondent, your company, all the monies that was made from those businesses, the company has a large share to take from those businesses? Would you confirm that? You split let me simplify it. Whatever business that you do on behalf of claimants, say under your management, you are presuming that you secured some concerts, tour performances, and they paid, right? You made money. From those money, who take the largest share?
What do you expect?
Who take the largest share?
Okay, we take the largest share. I mean, we have to recuperate our money. That's stated. If you also invest, you get your money now.
So you take the largest share.
Okay.
Now, all this recuperable money and investment that you've done, from whose share do you recoup all those ones?
From whose share?
Whose share of the money, from whose part of the money do you recoup all those?
No, just like is a percentage. Once, okay, this percentage goes to her, our percentage goes. We don't now.
I understand that. I'm asking
Okay.
the recoupable money, the living expenses, education money that you are saying you're going to recoup. On whose part of the money do you take those for?
I believe all those have been factored into our part of the money. So I don't think I still get you.
Let me, just because you are not aware of the business of your client, I'm going to help you out here. All those are recoupable from the claimant's share, the little share of her business.
If you say so.
Honorable Tribunal, she has just answered her own question.
That's
he
part
gave
of
an
the
answer.
conduct. He answered that I just
Yeah.
made a little clarification because he doesn't know.
No,
No.
he
I
answered
answered,
the
yes,
question.
Yes.
She's
I said it has
telling
been
him.
factored into
Can
the
you
percentage.
let your respondent?
Yes,
let them
he
speak.
answered the question. She's telling him what she wants him to say. He has answered. It's from the chair.
So
She's saying no, it is not.
If she chooses to use her 30 minutes to ask the witness questions and answer the questions, well, I mean, she's not the witness. We want to hear from the witness. It will go in the record, but it's not the witness that said so.
Okay, we just want to bring to your attention.
If she chooses to use her 30 minutes to cross-examine herself and answer, that's up to her. You know, but we're going to take note exactly of what the witness is saying. Don't worry, I understand exactly, you know, the case of the parties. I know what the witness is saying and what she is saying, so it's okay. So claimant's counsel, I think you should take note of what I've just said.
Yes, I think
choose to use your 30 minutes to cross-examine yourself.
I'm
all
not
well and good.
He has answered the question. He said he doesn't know, so I just made a comment on that.
Can you repeat your answer?
She said on whose side or on whose part is the money recouped from? I said all the recuperables have been factored into the company's side or the label's side of the profits and all of that.
Please look at, can you take a look at your statement of account? Can you read the paragraph after this account statement? Can you just read it out?
The paragraph after the account statement.
The summary.
Summary.
Honorable Tribunal, these documents are before the court, before the tribunal. He's to answer questions.
This is cross-examination, your respondent.
Not read the evidence to the
No, you can put a document to a witness during cross-examination, right? Which I believe that's what she's doing.
Yes, I'm saying the document is before the tribunal. She's telling him to read the document to the tribunal, which is already before you. So if she has any question as to anything,
but don't we go for hearings where the document is there and they say read paragraph XYZ? Yes. Okay. It's not a strange, for we lawyers, there's nothing strange about that. What I thought, what I was about to say was, can you tell the tribunal exactly what the document is so that we can all follow you in terms of what you're trying to do with that document?
We are referring to this trust statement of account, and we are asking the witness to read out loud the summary of the account.
Can I read now?
Yes, go ahead.
Summary. This trust account statement details the deposits and withdrawals made on behalf of Ingrid Phillips. The fund include contract advances, royalties from album releases, streaming revenues, endorsement income, investment returns, and licensing income. The closing balance reflects the total funds held in trust after distributions to Ingrid.
Thank you. The question is, what distribution are you referring to?
I don't understand
From
the
the part you just read, you said the closing balance reflects the total funds held in trust after distribution to Ingrid. What distribution to Ingrid are you referring to?
After distribution, I think I mentioned earlier that I think the 50,000 is being paid to her. I think I said something in that regard. I did.
I didn't hear that part because you didn't.
I did. You asked me.
And the question is, what distribution are you referring to?
Distribution. It covers every other thing that's come.
Please give us a clear answer. What distribution are you referring to?
I said distribution covers everything that comes before. He said and all other distributions. So I mean, I don't know why you're
singling out. We are not sure of what distribution. What distribution are you referring to? There are several statements on the account showing inflows that you've just highlighted. Inflows like contract advances, royalties from album sales, and endorsement income, and so on. And you said the closing balance reflects the total funds in trust after distribution. What distributions?
I'm still trying.
This question is flowing from me asking, where did you recoup your own part of the expenses? You said it's already factored into the respondent's share of the money. And then you're referring by this statement further distributions to Ingrid. So what distributions?
No, I don't think I'll be able to answer that.
Thank you. Would you say the statement is after you've recouped all your, this current balance you're looking at is after you've recouped your money or before you've recouped your money?
Let me see this statement again.
we need to move to certain questions. Legal.
I want that one to close my case. I know what I'm doing. That will be the final.
You know, we've spent like 10 minutes or more on only trust account. That's not only our
Okay,
case.
what's other one?
There's legal disability.
Which is the last question.
Okay.
Any other one?
I just wanted to point to that, but there was what the one was also saying.
Please, contract advances.
Please, witness, our time is going.
What was your question again? You said, is this after?
He said it was recorded from Respondent, but this shows that it was recorded.
Well, since you don't understand the question, you've given me the answer I want. You obviously don't know the business.
He just asked you. He said, what was your question again? If a,
I
if
said,
a
what
witness does not understand, you have a duty to make him understand your question.
The question I asked you is based on the account you've just read out. What distributions were you referring to that you made to
I think you
Ingrid?
moved from that. You were asking something before and after.
I asked before that from what shares does your record label recoup their own share of the money? You said it has been factored to the share of the label.
Yes.
And then you went on and read the summary of the document, which read that the accounts that we are all looking at now is after distributions have been made to Ingrid.
To Ingrid, yes.
And I'm asking what distribution. You were unable to answer that. And then I went further to ask, this statement of accounts, the figures that we are looking at, would you say is it after the labels have recouped all their money, or this account is reflecting before the recoupment is made?
No, I think my statement will flow from my answer the other time. I think I said something about I don't know the figures and everything. So
you're not sure, you're unable to give us whether it's after recoupment or before recoupment?
I can't speak to that.
Thank you. Now, are you aware that at the time of signing this contract with the claimant does not have the legal...
Just a minute, claimant counsel, you have 9 more minutes.
Are you aware that at the time of signing the contract with the claimant does not have the legal capacity to enter into this agreement?
I'm not a lawyer, so I mean, I don't know. I know she was 15.
You just said that you are aware you signed at 16.
Yeah, I said it. I said it's
Are
so,
you
and I
aware
said
that
it. I
doesn't
said
have-
15 is minor. I said it in my first
Are you
answer.
aware that she does not have the do you confirm that she does not have the legal capacity to enter into the contract?
I said if 15 is
as a minor?
considered as minor, yes. I said that.
Are you aware that by your contract in clause 17, the contract said that 7.6 rather of the recording contract, it asks that the parents of the claimant or a legal guardian co-sign the agreement. Are you aware of that fact?
If it's there, yes. If it's there.
And are you aware that the execution space for the contract is not signed up to date?
Well, you know I'm not the managing director, right?
Are you aware is my question?
Sorry.
If it's there, yes, I mean.
Tribunal, we raise objection to that question. The witness had already made a statement that is not the recording manager in this agreement.
And I've moved on from that question.
But the question
and I'm
you're
asking
asking
another
him
one.
again is to the details of the contract, which he was not a party to.
But he's testifying. The witness is testifying on behalf of the party to the contract. So really, those are questions that can be put to him. That contract is a substantial part of this dispute. So really, those questions can be put to him.
So you confirm that you are the manager. So you must be aware of all the contracts that the claimant signed or is signing.
Okay.
You are aware. So you are aware of clause 7.6 of the recording contract.
Please read it to me. I mean, I don't keep the clauses.
Okay. 7.6 of the contract says the parties acknowledges that under the Nigerian contract law, person below the age of majority, which is 21 years under the common law, may lack the capacity to enter into binding contracts. However, contracts for the necessities and beneficial contracts of service remain binding. The parties agree that this agreement constitutes a beneficial contract of service intended to prepare the parties for a livelihood and professional career. In the event that the artist is under the age of majority at the time of signing the contract, the artist's parents or legal guardians shall execute as guarantors, consenting and guaranteeing the artist's performance of our obligation. Such guarantors shall be jointly and severally liable with the artist for the artist's obligation hereunder. The artist warrants that our execution of this agreement, together with the consent of our parents or guardian, renders this agreement valid and binding upon our under contract law. Are you aware of this particular clause?
Yes, I am.
So why did you not take any action to ensure that this contract clause is effective?
So if you notice when you were reading, I think you said with the consent. It doesn't mean the parent has to sign. So, I mean, when I was told the parent already consented or something.
The question is, why did you not take effect of this particular
I'm telling
as a manager?
you why I didn't raise anything in that regard.
Thank you. That will be all.
Okay. Any re-examination? Respondents?
Thank you. Yes, we just have a few questions. Can you confirm to the arbitral panel that you have no degree in finance or any special skills in accounting?
I answered, I don't have degree in finance. I don't.
And you're also not a lawyer, so you might not understand some technical terms of a contract.
I am not a lawyer, no.
Thank you, that will be all for now.
I have no further questions for you, but I have questions for them during the submissions, but no questions for you.
So I can go?
Yes,
thank you.
You're discharged. Thank you. Any more witnesses, respondent? No. Okay. Thank you, everyone. I think, they're going to take closing submissions, Dr. Then we adjourn. So thank you, everyone. At the beginning, I'd announced already that we're going to have 5 minutes of closing submissions each. Please limit it to 5 minutes. We're behind schedule. But let your closing submissions, I haven't heard the evidence from both sides. Let your closing submissions address the key points you would like the tribunal to focus on in terms of delivering the final award. Now, because the respondents have finished, the respondent's witness have been called last, they will start the way we typically do. So respondents, you will start with your closing submissions, and then claimants will conclude with their closing submissions. So 5 minutes, please.
Yes, thank you, Honorable Tribunal. We'll first begin our submission explaining the objections that we had earlier. And our objections, like I said, was premised on Section 31 of the Arbitration and Mediation Act, which gives this court the power to determine the weight that it attaches to any evidence. Now, the soul of arbitration is that parties can agree to the procedure and timeline within which they file processes. We had agreed to timelines in this case, which were not respected by the defendants. So they took us unaware of so many processes. They had filed within time only their points of claim and an unsigned memorial. And we took that into consideration to bring to your attention that the only valid memorial before this tribunal is unsigned and cannot and should not be relied on. In DCOI and NSITF Management Board, the Supreme Court, in 2025 case, emphatically said that an unsigned document does not have any efficacy in law. Such a document is worthless. And this is the only document that they filed within time, in addition to their points of claim. So we are saying that the only process that should be relied on by this tribunal of the claimant is their points of claim. They front-loaded no exhibits, so they have no evidence before this tribunal to substantiate the claims that they have made in their claim. So we urge this tribunal to rely on only their points of claim simpliciter in coming to its conclusion. Now, going to the issues, whether the contract was a valid contract. Yeah.
That, and I apologize, I may be interjecting as you go along.
Yes.
Before you go into that, you refer to the Supreme Court decision on an unsigned document, being a worthless document. Now, would you say that that decision would also apply when it's unsigned arguments, legal arguments, which they could as well canvass orally? Because now parties, they've put in together written submissions, and you are asking the tribunal to disregard written submissions because they were because the person did not sign at the bottom of their legal argument.
Yes.
Now, the document that you ask me to disregard is not evidence. It's not a document to
on the arguments they make orally, but the arguments that they choose, that they canvass in writing, trying to persuade you
you should not even see it, because that document should not be before you, because it should not have been admitted it should not have been accepted for filing ab initio. That's what we are saying. There are persuasive arguments in there, and ones that they probably may not say here, that could persuade this honorable tribunal. So they are improperly before this honorable tribunal. That is our point. So they are improperly before this honorable tribunal. That is our point. That is our point.
Okay.
So do I have your permission to go on to the
go
issues?
Ahead. Yes,
Okay.
Yes. Go ahead.
So the first issue is
Go ahead. Yes, yes. Go ahead.
So the first issue is whether the contract is valid. And really simply, we don't want to waste time on the issues. This contract was signed for the benefit of Miss Ingrid. And she did receive these benefits. The account statements that were tendered show that these benefits accrue to her. And proper accounting was done by BM Records to ensure that she derives these benefits. She was given monthly allowances just to support her. Her mother even said that she was aware. And we also know the inconsistencies in the testimony of her mother. She said she's semi-literate, and then the contract was explained to her. The person who explained that contract to her is not here. So everything she was saying was based on what she heard. And we don't think that this honorable tribunal should her statements, because she claimed to be semi-literate. She didn't understand, but she was told what it meant. We can't rely on this, because this is hearsay. Even though the rules of evidence don't really apply it to this honorable tribunal, it is purely hearsay. The person who told her of the content of the contract should have been brought here to testify as to the veracity or otherwise of it. And that is where we end on the first issue. We hold that this contract is valid because it was beneficial to the claimants, and she did receive these benefits. To the second issue of whether the respondent's actions in setting up the trust were in good faith.
Hang on, I have a question for you on the first
Okay.
point. So when you say that the contract was beneficial, when you say that the contract was beneficial to the claimant,
yes,
I've read your submissions as well.
Yeah, of course.
Is your point that the contract was solely beneficial to the claimant, or is it that it was beneficial to both parties?
It was beneficial to both parties, but I don't think those points are at odds. I don't think those are contradictory statements. If it being benefit to both parties and it being beneficial to her, I don't think those statements are
there's a legal angle to it. That's why I ask. If it was is it a contract that was solely beneficial to her? In law, it's a totally different angle in terms of the issues in dispute as to whether it was beneficial to both of you. And I will address that in my ruling. You will understand why I asked that. But I get your point.
But we hold that it was largely beneficial to her.
So, your submission is that it was largely beneficial to her.
Yes. Then on the second issue of whether the claimant ratified the recording agreement, the claimant said here, and the exhibits before this tribunal, which we tendered rightly and in time, which the tribunal should rely on, are social media posts of Ingrid Phillips expressing her excitement of recording albums, being in the studio, working with BM. I don't think anyone who is dissatisfied with a contract with a record label would be so excited enough to make videos of her spending the benefits that she has received from the record label and from her boisterous career. I don't think that that person will have such a time. Her mother claimed that she was depressed, but she was on social media all over the place making posts of how happy she was. We see this as ratification, and we see this as her in her full-fledged adulthood, embracing the contracts in which BM offered her when she was seeking opportunities in her life to better her career. I would, with the permission of this honorable tribunal, to defer the third and fourth issue to...
So hang on, just before you go into that third and your final issue. The social media post, how old was she when these posts were made?
19.
I have 2023, 2023, 2022 here.
She was 18 and 19.
She was what?
She was 19.
She was 19 at the time of the social media post.
Yes. Because at the time the contract was entered into, she was 16. I was 3 years prior, so she was 19.
But is it that she didn't make any posts before this post?
Well, we're not.
Well, what you have in evidence is the one that she made after
yes,
this.
yes. And with the kind permission of this tribunal, I'll defer the third and fourth issue to my colleague, and then I'll take the final issue.
Okay.
Thank you, Honorable Tribunal.
I understand that you have 30 seconds more, but go ahead. Maybe we'll give you an extra minute.
All right. What we have on issue 3 is whether the respondent's action in setting up trust for the claimant's benefit constitutes sufficient consideration and evidence. I think our simple answer to this is yes. And we'll go further by stating that we clearly recognize the importance and also the essential element of a valid contract is consideration. But we'll go further and state that the Supreme Court has in plethora of cases stated that consideration need not be adequate. It just needs to have value in the face of law. And one of these cases is Union Bank of Nigeria versus Alhaji Adams. And while we stated this particular case for you is to know that we have actually gone above and beyond what the court has stated as what is consideration by actually opening a trust for her, which obviously, if you know what a trust means, as the claimant can affirm that we opened a trust for her, a trust is catering for her future, which means that we did it out of our good faith. We did it because we care for her. We just did not give her the money because we knew that at that point she might be below 8. She was below 18 years old. But we opened a trust that she will have access to when she will be 18 years old. And we actually did give her access to the trust when she was 18 years old. And that was part of what we already submitted. That was part of what was submitted in the statements of claim and also in our statements of defense. And also on issue 3, also on issue 4, which is that is Ingrid entitled to unilaterally repudiate the contract without consequences? I will say no, she cannot do that. Because the Supreme Court has also in National Electric Power Authority versus Joseph stated that a party cannot unilaterally, and this borders on the principle of estoppel, which means that a party cannot approbate and reprobate at the same time. And many Supreme Court cases has also affirmed this decision, that you cannot blow hot and cold at the same time. You cannot actually affirm to the existence of a contract, which means her going to the studio to record her albums and everything, and the record label has actually released that, which means she has been affirming to the...
Meaning the person by whom the arrangements for the making of the sound recording are. We interpret that to mean the person who facilitated the recording of that recording, as the case may be. The person who, and in this case, which they also admitted in their points of claim, that BM Records facilitated, financed, and kind of did the entire process to ensure that those songs were recorded. That is how we interpret Section 108 of the Copyright Act. And assuming without conceding that BM Records is not the first owner, these rights in the masters have been perpetually and licensed and assigned to BM Records by clause 7.2 of the recording agreement. So even though they hold, or even though this tribunal finds that BM Records is not the first owner, therefore the author, therefore the first owner of Gyration, they have been assigned the rights perpetually, meaning that they own it, meaning that the claimant cannot license the rights in the master to any third party without the consent of BM Records. We concede that she can license the rights in the composition, which she did, but she did that alongside, if we exhibited the agreement between her and Medusom Films Limited, and it's seen as a song and master recording license. So she overreached. She licensed the rights she had and the rights we had, and she gave what she does not have. So we see that as a huge breach on our contract and a huge breach on our intellectual property rights. And on the breach of the contract, there's a warranty in the contract, in particularly clause, I don't remember the clause now, but that says that the claimant warrant, or the Ingrid warrants not to infringe or transfer any rights which it has given to the record label to a third party. And she did so. So she has breached this contract. And on this basis, we say that we are entitled to the relief sought in our counterclaim. And we so hold. And we pray this honorable tribunal to grant our relief and dismiss the claim of the claimant.
Thank you.
Okay. That's it. Okay. Thank you. Thank you, respondents. Claimant, over to you.
Thank you very much. So I want to briefly address some of the issues that the respondent team, they've raised over the course of this arbitral proceeding. One of it being the unsigned document and how it has affected them per se. So in the course of this very brief address, I'll be referring this Honorable Arbitral Tribunal to certain key provisions of the Arbitration and Mediation Act 2023, which is very important for us to look at. So I invite the attention of the Honorable Tribunal to Section 36, Sub 4 of the AMA 2023. And I read, unless otherwise agreed to by the parties, a party may amend or supplement its claim or defense during the course of the arbitral proceeding, unless the tribunal considers it inappropriate to allow any amendment or supplement having regard to the delay in making it. I want us also to look at Article 26 under the schedule of that AMA that guides procedures as it relates to arbitral proceedings. So Article 26 relates to interim measures that can be granted by an arbitral body. So I will just read. 1, Article 26, paragraph 1. An arbitral tribunal may, at the request of a party, grant interim measures. So paragraph 2 goes on to state what amounts to interim measures, and that includes attempts to maintain or restore the status quo pending determination of the disputes and all of that. But paragraph 3...
I'm just wondering where we're going with this. Interim measures have no bearing in what we're doing here.
So I want to show that, firstly, the amendment, if I may call it so, did not prejudice the respondent. We merely sent a signed copy of our points of claim, just that, attaching the signature, and this was done with the approval of this tribunal. So I just wanted to point that out, and that the respondents in this case today were not affected in any way by the mere insertion of that signature.
Point it out. Interim measures are like an interlocutory injunction.
Yes.
I don't think it has any bearing here. Yeah. So I think let's just go straight to the point.
Sorry, sorry, arbitrator. In addition to addressing the issue of the exhibits not forwarded I want this arbitration to note that we did not forward those exhibits, the evidence, because the respondents were put on notice to produce the original document. So as at the point we were serving our points of claim, we were not attaching any document to be relied upon. However, after receiving their own process, and we noticed that we still did not get the original copies, we attached all the documents that we want to rely upon alongside our statement on oath. So it still did not in any way prejudice or preclude them from preparing for that in any way. So that addresses the issue of prejudicial, whatever they are claiming.
Thank you very much. Moving on, there are 6 issues for determination before this Honorable Tribunal. And in order not to belabor the tribunal, we rely on those issues as raised in our points of claim and also our legal arguments in support of those points of claim. So the issue, as we've earlier referred to in our opening statement, the case before this Honorable Tribunal is an attempt by the respondent to enforce against a minor, basically a long-term recording contract, which in our arguments we've stated that it is wicked and exploitative. So I'm going to take issues as it relates to issue 1 and issue 2 as raised in our legal arguments. So, on the first issue, can we? I will need that section 17 ready, Tabek.
So just to be clear, we're giving them 10 minutes. So out of your 10 minutes, you have 6 more minutes.
So on the first issue that we've raised in our point of claim, whether the basically the validity of the agreement signed at the age of 16 without parental consent as well, and also the further repudiation of that agreement by the claimant upon attaining majority leaves that contract void or voidable in the other alternative. So we've, in our points of claim, relied on authorities like Section 17 of the Child Rights Law of Lagos State, and also binding authorities like Labinjo and Abake. The citations are also can be found in our legal arguments. And can I just need to refer? I need to read this 17. Yes, it can't be alternative. Let me finish with it. I know. So please, with your permission, I'll just read out 17. So Section 7.3 of the Child Rights Law of Lagos states, except as provided in this section, no child is capable of entering into any contract. Particularly 3, which is very important. Accordingly, no action shall be brought against a child by a person after that child has attained the age of maturity to pay a debt contracted as a child or ratified or any promise of contract made as a child before majority, whether there was consideration for the promise or not after the child attained maturity. B, that's 3B. If a child, having contracted a loan which is void, agrees after majority to pay the loan, the agreement in whatever form shall be void, inasmuch as it relates to money which is payable in respect of that loan. So the respondent argues that by continuing to perform, this is another argument, that by continuing to perform and accept payment, the claimant ratified the contract upon attaining majority, and it is the position of the claimant that this cannot stand. The authority I just read out expressly bars ratification of voidable infant contracts by mere conduct after majority. Ratification must be clear, it must be intentional, and ratification does not amount to passive continuation under economic compulsion. So there are other arguments as to our other issues, repudiation without consequences and all of that, but I'm just going to pass it to my co-counsel to take some of those issues.
Okay. Thank you, Arbitrator. We will be relying on all the arguments in our case, but in our deliberation, we want to quickly point out the issues raised during the trial on the issue of the trust account statement. It is our argument, our contention that the current trust account tendered by the respondent or given to us is, from even the face of it, the document speaks for itself, is not a comprehensive account. And we cannot even identify what inflows, outflows, withdrawals, or the how these numbers are being come up with. So we cannot even rely on this trust accounts as it were. And so because of this, we are praying this honorable court not to rely on this trust account and hold that the respondent has defaulted in their fiduciary duty, both under the management and under the contract, to execute the trust relationship or business that they've entered into on the accounts of the claimant as they have claimed. On the other hand, we are also arguing that this trust, quote unquote, that the respondents have unilaterally created on behalf of the claimant is nowhere founded, either by the contracts or by express agreements to create such trust relationship. And on the issue of licensing the master composition of the song Gyration, again, I also want to refer this arbitration to the agreement that has been forwarded in the body of hearing of the synchronization license itself, dated the 3rd day of January 2025. If the claimant has repudiated this contract by the notice of repudiation sent to the respondent in 2023, and by that notice has reverted all her rights, her composition and ownership to herself, it's her argument that she has the legal right as the owner of this song Gyration to license it to whoever she wants because it forms part of her Copyright Act. Also, by the section...
Just a moment, just to interject. So the point is that your argument is that upon service of that notice of repudiation, the contract was deemed repudiated, and the song Gyration was recorded or licensed or whatever it is after that notice of repudiation. And so the argument that you still maintain is that the rights to that song vest exclusively in the claimant.
In the claimant.
Okay, understood.
And also in support of the argument that the claimant has the exclusive right to license and own the master's rights, even publishing rights to that song, or the ownership in the right, we are resting this argument on section 30 sub 10 of the Copyright Act, which is based on the assignment license, and provided that all future works, the right to all future works, that is, works that have not been created, cannot be assigned. If you intend to assign it, at least the work must be identifiable. If you intend to assign any future rights that is going to be in future work, it must be ascertainable. And as at the time, this contract that the respondent is relying on to acquire all the rights of the claimant, this particular Gyration work has not even been created. And there is no express written or implied agreement to show that the claimant intends to transfer that right to the respondent. So if they don't have any legal basis for the ownership of this Gyration, how then can they be claiming that the respondent has breached, the claimant has breached the Copyright Act or their ownership, or even breached the contract as it were, when we are saying in its entirety the validity of this contract should be questioned, where the validity of the contract is even can be even upheld. The claimant herself had validly repudiated the contract.
You have 1 more minute.
The claimant herself had validly repudiated the contract shortly after attaining the age of majority, which is the age of 19. Thank you very much.
Okay, just one question before we wrap it up. How do you react to the testimony of the claimant's mother, Mrs. Phillips, when she said that she was aware, even as at when her daughter was an infant or a child, when she said she was aware that a contract was signed when her daughter was about 15 or 16 or thereabout? How do you react to that?
Our reaction to that is that she's semi-illiterate, and she had clearly stated before this tribunal that she never even saw the contract as it were, that she was only informed of the benefits that would be accrued to her daughter under the contract. And as it were, the contract has already been signed because her daughter came home to inform her that she has signed a record contract. And she also gave in evidence that upon she went to the label to confirm the contract, and they only inform her of the benefit. Nobody told her that her consent is required, or neither did she have any independent legal advice to advise her whether to, validate the contract or invalidate or invalidate the contract.
Okay. Thank you very much, ladies and gentlemen. I think we're going to call it a day here, and the next time we will meet will be for me to deliver the final award.
Sorry, I think you said you had a question for me when I was objecting.
Huh?
You said you had a question for me when I was objecting, but you would ask later.
So you want me to stay here and continue asking you questions? No, don't worry. It's been overtaken by events. Yeah.
You have luck.
Everybody now has an idea of how, an arbitration, takes place, and, what is involved in resolving these disputes outside of the courts. And of course, getting everybody to get to the table and reaching a resolution that benefits everybody. Please, once again, put your hands together for the arbitrator and the arbitrators. So there's this funny story I like to tell. I used to travel to the village as a young kid, and part of the things I enjoy doing in the village is playing football. But we had a problem, right? And the problem was, whoever owns the football or owns, the ball that we're playing seems to be the king of, the match. So you don't want to offend the person who owns the football. So we had something that we organized each year, and what we used to do is everybody, sets aside a team of 7 man, a 7-man team on each side, and then they have their names printed on, see-through vests that anyone could wear, and then come and compete. But there was one problem. There was no referee. So whenever there was a foul, the person who thinks he was fouled will grab the ball and then keep shouting, foul, 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 until everybody comes to the pitch, tries to resolve the issue, and then before you know it, it's 7 p.m. and then we have to go and then we'll play the match again the next year. Now, the next year, we went to someone in the village to sponsor the match for the year. And, it's something we look forward to. And then he said he was only going to sponsor, the team of the year, which was, I think it was 50,000 thereabout that he was going to give to about the top 3 teams for that year. But one condition, there was always going to be a referee for each match. He was tired of hearing about matches getting cancelled, someone grabbing the ball and then leaving the pitch. And then something happened that year. We stopped having somebody grabbing the ball and shouting at everybody, and then, it's 7 p.m. and everybody goes home. This time, we had seamless matches, and we always had a winner at the end of each day. At least, if it wasn't, if it was a final, we'll have a winner. If it wasn't a final, then, points were recorded. Why did I tell you this story? One thing, an arbitrator is not just there to just listen to the counsel who is speaking. An arbitrator is there to make things make sense. Give each person, an opportunity to table their issues, but more than anything else, allow people to reach resolutions that keeps everybody feeling strong, happy, and at least taking one thing from the pitch. If there's anything I took from, the arbitration session we just had, is that the arbitrator is very important in making the counsel and, the aggrieved parties, feel like they have a listening ear, someone to guide everything and have everybody ending their matters strong. Now we're going to move to the next session, and this next session is really interesting, and it's about AI. I mentioned earlier that sometimes I'm afraid that my phone will one day wake up, turn off the lights, and electrocute me in my bed because of how intelligent our phones are getting. Now, there's a question. Does AI democratize creativity, or does it endanger creativity in Africa? We're going to be calling, the top 3 finalists to come and defend, their positions. They're going to be taking up the seats on this side of the table. and we're going to have one judge. Quickly, we're going to call on the judge. Now, this judge is really impressive. When I read her bio, I like to shorten my bios. I don't like to read typically long bios because I like the audience, understanding who I am calling on stage without reading all the boring stuff in the bios. She's a champion of creativity, just like we have several champions of creativity here. I see Uncle Mo somewhere in the crowd. So she's a champion of creativity. She's a modern day champion of creators. She's a digital native. She has a YouTube page that goes by the name Omobi. She's a forward thinker who sits in the intersection of media, tech, and entertainment. And she's a bridge between law and creativity. Please put your hands together as I welcome Omobolanle Abiola. Please put your hands together for her. She's going to be the judge for the debate. Please put your hands together for her until she gets on stage. Omobolanle Abiola, you're welcome. And then quickly, I'm going to go ahead to call our debaters. So as I said earlier, our debaters are going to sit on the side. Our debaters are going to sit on this side and then present their cases, or at least defend their cases. You have 5 minutes each, please. I'm going to be timing you, so stay within time. You have 5 minutes each to defend your cases, and after that, the judge is going to have some time to then adjudge the winners, and then I'll call the awarders of the awards for the debate. So quickly, without further ado, our final debaters are Vera Anako. Please put your hands together for her. Vera Anako. Please also put your hands together for Paul Abimbola Olatunji. Paul Abimbola Olatunji, please come on the stage. And lastly, Richard Uyok. Please put your hands together for the debaters. It's not easy until I give you the mic and ask you to come on the stage. I remember one story. The first time I did a debate, I was in first year in uni. And I was given the mic and then, take up, the podium. And then it was the first time I was using my Lord, my Lord. Everybody wants us to, simulate real life debates. If you've ever debated, let me see your hands up. Have you ever debated? If you ever debated? Nah, you guys have real balls to come up and debate. So now this was my first time. Eyes on me, everybody looking and staring, what's happening? I get on stage and after each point I shout, my Lord, this is what I think the claimants are wrong, I think this. But the church boy in me snuck out without me knowing. In the euphoria of debating and having people listen to you and shouting, my Lord, the pastor's child in me just jumped out and I shouted, my Lord, my God. And the whole hall went out laughing. So I was given a little time, get my composure back and get back. So it's not easy. Please put your hands together again for the debaters. They have 5 minutes each. I'm going to hand over the mic to the judge now.
Okay. Hi everyone, can you hear me? Please let me know if you can hear me. Thank you. My name is Omobolanle, also known as Omobi. I am the judge for this particular session. Just to remind us all, the title of the debate is, does AI democratize or endanger the creative economy? And we have our... Okay. And we have... And we have our debaters on seat. We have our debaters on seat and they would introduce themselves. So what you're to do, first of all, is to introduce yourself and the side you're picking. And afterwards, I will just quickly lay down the rules and then we'll begin.
Okay, good afternoon. I am Vera Anakor, and I am on the side that states that AI endangers Africa's creative economy.
Thank you. Next person.
Good afternoon. I am Paul Olatunji, and I wrote on the two sides. AI is endangering and democratizing at the same time.
Okay.
Hello, I'm Richard Uyok, and I said AI endangers. I said AI endangers the Africa's creative economy.
Okay. Maybe you should.
Okay, my name is Richard Uyok, and I said AI endangers the African creative economy.
Okay, so
Yeah.
obviously we have two people that have picked the side, endanger, and then we have someone who has points for both sides. So one person would have to speak on democratize, because the point of the debate is for us to look at both sides and to determine whichever one we're going to go with based on the strength of your argument. So I know Vera is speaking on endanger. You want to speak on endanger, so Paul? You speak on democratize.
Let me just stick to endangering.
3 people cannot speak to endanger, and time is counting, so one person has to. No, you're not on a chopping block. We're not going to kill you if you don't have strong points, but I believe that you do have points for both, so. All right, thank you. Quickly, so what I would expect from you is to give legal arguments, right? I would also expect you to give, you're speaking on endanger, so basically you're sticking to a side. Give legal arguments as well as evidence for your argument. That's the most important thing. So that way we are well informed of why you hold your side. Okay, so you have 5 minutes each, and we'll begin now. If you can use less than 5 minutes, that would be great too. Use the mic in front of you, Vera. Okay, if you want to stand as well. I think that would be great.
Hello. Oh.
Your time's up now.
Africa's creativity is on the rise. Afrobeats are shaking the world. Knowledge is lighting up global screens. But just when the world finally listens, artificial intelligence steps in, cloning voices, stealing stories, and erasing names. That is not liberation, it is theft. Good day, organizers, my honorable adjudicator, co-debaters, and my valued audience. I am Vera Anakor, a fourth-year Babcock Law student, and I stand firmly to argue that artificial intelligence endangers the African creative economy rather than democratizing it. When we speak of democratization, we speak of access, we speak of ownership, inclusion, participation. This debate is not about whether AI has potential or not. It's about who controls it, who exploits it, and who benefits from it. It's about who controls it, who exploits it, and who benefits from it. I'll be backing my stance with 3 strong points: copyright violation, economic and cultural appropriation. For my first point, copyright violation. In June 2024, the Recording Industry Association of America filed lawsuits against 2 AI giants, Suno and Udio, for mass copyright violation. Why? Millions of songs were copied and used to train their AI models. If the richest artists need the courts to protect their rights, how much more African creators? Here we have the weakest shields. Only 70% of African countries have even basic data protection laws. Our oral traditions, our songs are not even recognized under copyright because they are not fixed. If this is the case, then it leaves an exposure. Afrobeat rhythms are already being fed into algorithms. South African artworks are found in AI data sets. If that is the case, then we are exposed. My second point is cultural exploitation. Only 3% of global AI talent comes from Africa. Yet, our African cultural data, our languages, our music, our art, are used in AI models we do not know. And they are found everywhere in Silicon Valley. Yet, all the wealth goes outwards, while Africa is left with empty praise. This is digital colonization. A Nigerian producer in 2023 named Eclipse Nkasi made an AI-powered Afrobeat album. If our own artists are already experimenting with these machines, imagine what the outsiders will do with our culture, especially when they are being driven by profits. Culture is not just content, it is our identity. If we allow AI to strip it of its value, then what more do we have left? Africa's culture is its greatest wealth. From Maasai beadwork to Yoruba folktales, AI copies this and remixes it without any form of respect. No regard is left to our culture. AI copies it and we are left with nothing. When this context is stripped from us, then we have nothing left. Our culture is all that we have to hold on to. If we allow those cultures to be taken away from us, then we have nothing. My third point is economy. Africa already earns 60 to 80% less than their global peers. Now we have songs and so many works are being distributed on Spotify and YouTube. These things are okay for the audiences and they do not cost anything. How can young African creators compete with a machine that does not sleep, that does not demand pay, and that does not respect originality? If that is the case, what is the point of labor? What is the point of working when everything is going to be taken away from us? Imagine an AI system coming out with Kente-inspired designs while Ghanaian weavers are left to starve. That is cultural appropriation. If you look into it, I want us to ask ourselves these questions. What is democracy without justice? What is access without ownership? What is creativity without protection? Do we want a situation where Africa can own its creativity, or one where it is taken away from us, repackaged, and sold back to us? I beg you, and I warn you, Africa cannot be fooled again. I know that my opponents will try to dazzle you with promises of access and opportunity. But Africa has heard those stories so many times. From colonization to globalization, each time the same thing has happened. Others took the wealth, while Africa was left behind. Why would AI be any different? A tool that promises to democratize creativity, but in the real sense, it leaves us endangered. Let us be wise. To be forewarned is to be forearmed. AI is coming, and it is coming at a very fast speed. Please, Africa must not be fooled again. Thank you.
Thank you. That was in 4 minutes. Paul, you have the floor. Well done.
In a continent where reading beats in the street, art piece on the wall and storytelling is a cultural lifeline. The African creative economy is more than just an industry. It is the soul of Africa's identity and a critical engine for economic transformation. However, as this industry expands, it stands at a critical point, facing the destructive power of artificial intelligence, which is rapidly reshaping the global creative landscape. However, this transformation, characterized by the introduction of tools capable of generating music, designs, art, and scripts, raises a fundamental question whether this transformation is a Trojan horse that threatens to endanger the African creative system, or a gateway to democratization of the African creative economy. My name is Paul Abibola Latunji, and I will be speaking on the democratizing aspect democratizing aspect which artificial intelligence provides to the African creative system. And my points include the following. 1, the African creative system has been empowered by the usage of artificial intelligence.
Paul, you want to take a breath?
Artificial intelligence has empowered African creative system by creating a level field for African creators who has always suffered.
Do you want to take a breath? You rather sit, but the thing is you have to make sure that you're audible and everyone can follow you.
So
feel free to look at your notes. You don't have to speak from your head. Okay.
So,
are you ready? Are you sure you're ready?
Yes, I'm ready.
Okay, so
the point I was trying to mention is that AI has proved to be a powerful engine for democratizing of the creative economy by creating a leveled playing field for African creators who have previously faced significant resources and access limitations. In the past, Aspiring filmmakers, musicians, and other creative required substantial financial resources, industry connections, and formal education to break into the industry. However, artificial intelligence technologies are now providing affordable and accessible tools to break into the industry. My second point is going to be based on the emergence, on the advantages that artificial intelligence has been offering to creatives. The emergence of AI has translated into a new world of possibilities in terms of productivity, thereby lowering, also in terms of lowering of production costs, streamlining workflows, making high-quality content more accessible, and saving up valuable time and resources. It is very evident that the efficiency gains are undeniable. For instance, writers can use AI to brainstorm plot lines and refine drafts. Musicians can experiment with AI-generated beats, and filmmakers can automate part of the editing processes. These capabilities therefore enhance creators to focus on the more nuanced and authentic aspects of their work, the human spark that artificial intelligence cannot replicate. It is worthy to mention that in 2023, Nigerian music producer Eclipse Incancy used AI to produce the 9-track album, a process that would have required him to spend much time in the studio, and this also would have required him to pay exorbitant fees to producers and other music stakeholders. Also, Nigerian artist Kwate utilized artificial intelligence to create a full music video for his song Using Boat, a project that would have otherwise required him to pay a substantial amount to cinematographers. And we can see that these instances demonstrate how artificial intelligence is democratizing the creative process, allowing artists to bypass traditional barriers of time and money, and instead to bypass traditional barriers of time and money, and instead further resources into their unique creative vision. My last point is going to be based on the fact that it's going to be based on the integration of artificial intelligence into the global streaming and social media platforms. Through this, the shift has fundamentally changed how African creatives gain visibility and connect directly with audiences, thereby bypassing many of the traditional gatekeepers that once controlled access to a global stage. This has been exemplified in the fact that before an artist can actually come to limelight in Nigeria, you have to go to radio stations to give them your CDs to play, or you have to meet with top record label producers. But then, through the use of TikTok
Your time is up.
Through the use of TikTok
Finish your sentence. Finish your sentence.
Okay, through the use of social media platforms like TikTok, and through the integration of certain AIs into streaming platforms like Spotify, artists now have artificial intelligence is now giving artists the advantage of making their songs to be. Similarly, Spotify personalized the recommendation engine, which empowers features like Discover Weekly, and release data uses AI to introduce new music to listeners based on their unique tastes.
Thank you. Please give me a round of applause. It's not easy to decide on the spot what you want to talk about. Richard, my apologies.
Yeah, everybody can hear me. So, my name is Richard, and it is my contention that AI endangers the African creative economy. So, most of the ideas are similar, so I'll just try to crystallize with real-life examples, right? So, first off, the most important context is that AI is here to stay, right? So the debate is not whether AI is here. And the next important context to AI, right, reduces the barrier to entry, right? So anybody can literally become a producer. You can teach yourself because of how accessible these tools are. But the problem with this is the tools are not just accessible to countries have provisions for artificial intelligence. So you cannot say that deals with this, right? So because of how fragmented the laws are, even with enforcement, even in Western countries that are largely developed, these laws are not still unified, right? And I think a key example is Anthropic's case, for instance, right? So the first arm of the judgment said there was no infringement, right? Because they purchased those books legally. And then the second tranche says, oh, they were pirated copies, so they had to like settle for $1 million, I think, last week. So due to these fragmentations that already exist, it's going to be very difficult for African creators. Yamune, an AI-powered artist who is already charting on the Billboard charts, reportedly signed like a Billboard charts, reportedly signed like a record deal, like I think last week. So these are some of the considerations that deal, like I think last week. So these are some of the considerations that are going to go on with investors. I mean, already there's like dwindling investments in the Africa. If like artificial intelligence is making art easier to create, I mean, Netflix created a sci-fi series using artificial intelligence, and these are some of the threats that African creatives are going to face, because if an investor, for instance, can use like artificial intelligence to recreate a Nollywood script, what are the incentives that are there for them to like invest in the African creative market? So these are crucial considerations that need to be taken into consideration when you're talking about the democratization of artificial intelligence in the African creative economy. I mean, it's beautiful, right? Like, it's easier. I can decide I want to be a producer today and stay in my room to produce. Yeah, thank you. So I feel like it's like a Trojan horse, or is it Trojan gifts? I mean, it promises to give, but I think on a scale, it takes more than it gives. It endangers more than it empowers.
To grade the debaters, and then we're going to have, grade the debaters, and then we're going to have, awards given for the debate, and also for the mock, arbitration that we just concluded. The discussion on AI.
Hello, everybody. Room reset. Hello, everybody. Just wait. Oduduwa almost caught me. I said, hello, everybody. All right, guys, please, we're about to round up here, and we'll move to the other hall to start our sessions. But I wanted to, because the aim of this conference is to help people to learn, help everybody, to encourage everybody. So I came quickly. I'm not supposed to come up, but I came quickly to say that, and to encourage the young man. Please, can we give him a round of applause? The future for lawyers is really dependent on how you can marshal out your points, whether some people say lawyers can, excuse my French, can say the most beautiful nonsense with the most beautiful confidence. But I just want to encourage everybody here that just because you probably didn't do well today on stage doesn't mean that it's the end. There's such a vast career for lawyers. If you're not as eloquent as I am on stage, or you don't have the confidence to come on stage, there's a beauty and there's a world, ahead for you as a lawyer, and it's not the traditional route, right? So I came here to recreate it, which is why we have this conference. There's a billion and one ways for a lawyer to become established, and it's not in the traditional way. So please encourage yourselves and don't beat yourself down. And let's continue learning and enjoy. So give yourselves a round of applause. Thank you, everybody.
Currently grading both the mock arbitrators and the debaters. We're going to have a very short 2-minute music break. After that, we're going to have the awards for the arbitrators and also for the debaters. After the awards are given, we're then going to move to the second hall, Sahara Hall. We're going to have, people giving you directions, and then we'll reconvene there and continue with our panels and workshops. Please, we'll reconvene in 2 minutes. DJ, give us a music break. Thank you. All the arbitrators, if you participated, please, you can get back on stage. Claimants, counsel, all counsel, please get back on stage.
I go do more than intended. I go shoot up all their playpens. I go shoot up all their playpens. I can't do without their policy, I know. I must fall in with all my niggas above. If they want to bounce, person, he cannot be mine. Men just baku, if you like them, be right. I can't do without their policy, I go. I must fall in with all my niggas above. If they want to bounce, person, he cannot be mine. Men just baku, if you like them, be right. Swat them. I just feel like they can rise. Reload, do like they can rise. On the wall, do like they can rise. Anyone go them, do like they can rise. Anytime I fall, I go push them to the cup. Smack them, push them to the corner. Anytime I fall, I go push them to the cup. Smack them, push them to the corner.
Good afternoon again, ladies and gentlemen. Welcome back to the day that we're issuing the final award. It's nice to see everybody again. I must first commend parties for your candor, your professionalism, for the camaraderie that was displayed throughout the hearing. Well done, everyone. The final award is ready. I will proceed to deliver it. But before I proceed to deliver it, I wanted to mention that this is an excerpt, as you would appreciate, of the final award. The full text of the award will be sent to your emails accordingly or dispatched to you. But this is an excerpt. It's not going to read out the entire, what a typical award will typically contain. But it has like the main decisions, and then you can go back and study the main thing later. Now, in terms of I will start with the preliminary issues raised by the respondents. I will start with the preliminary issues raised by the respondent, which was pertaining to admissibility of documents, and admissibility of evidence. Now, when I say admissibility of document, admissibility of the memorial, unsigned memorial, put very late in the game, according to the respondent, or filed very late in the game, according to the respondent, by the claimant. Now, as you will appreciate, and as I'd said before, the tribunal cannot close its eyes to submissions of parties, whether signed or unsigned. The point will be, what prejudice will parties suffer if those submissions are not put in? Who will suffer more prejudice? And as far as the tribunal is concerned, the claimants will suffer much more prejudice if its written submissions are not before the tribunal. In view of that, I find that the respondent's objection on the admissibility of an unsigned memorial is dismissed. I also find that the memorial itself, as I'd said before, the whole mischief behind the law asking parties to sign or put together written documents is so that time is abridged, time for filing of oral submissions, or time for addressing the tribunal orally is abridged. And so in this case, if that is a mischief that it is trying to cure, I do not see the challenge with having an unsigned one. And as a matter of fact, and more importantly, there is no prejudice to the respondent. The respondent itself has not said to the tribunal that the unsigned version had more information, that the signed version had more information that the unsigned version did not have. So that objection is dismissed. In terms of the other documents in which the respondent addressed the tribunal on, and in terms of the admissibility, my understanding is that the tribunal had, or the claimant had sought permission from the tribunal to put in those documents before the hearing, and the tribunal had granted the permission to do so. So the tribunal haven't granted that permission to do so. I also find the respondent's objections dismissed. I had asked the respondent to address the tribunal on cost as to what it would suffer in the event that these documents are put forward. or for the respondent to consider if there were any costs to be suffered if these documents are put forward. Unfortunately, the respondent has not addressed me on cost, has not put forward any cost submissions on the point, and so I find that I'm not inclined to award any cost in favor of the respondent in terms of this objection, if indeed there was any prejudice or anything that has suffered on account of the late filing. So that addresses the preliminary objections put forward. We then go into the substantive matters presented before me for determination. Now, having carefully considered the pleadings, the submissions, and authorities cited by both parties, this tribunal now delivers its final award. On the first point, on the validity of the recording agreement. The agreement was executed when the claimant, Ms. Ingrid Phillips, was 16 years old, a minor under Nigerian law. Clause 7.6 of the contract expressly required parental or guardian consent where the artist is under majority. That condition was not fulfilled. The respondent, being the more sophisticated party, bore the responsibility of ensuring compliance with the terms of the law and with that contract. It is quite curious that although the claimant's mother was aware of the existence of a relationship between the parties, and the parties herein being the claimant, Ms. Ingrid Phillips, her daughter, and the respondent, the claimant's mother took no steps to seek legal guidance. However, this does not in any way cure the defect of express parental consent as required under clause 7.6 of the contract. The sophisticated party principle mandates that the respondent ought to have taken all reasonable steps to ensure that he was contracting with the right party. Capacity to contract is a bedrock of every legal and binding contract. It is trite that a child under the applicable law cannot contract, especially where the contract has such extensive legal and financial implications, as is the case here. The respondent itself has argued on an unrelated point that an unsigned document is a worthless document in law. I find that this principle will also apply to the contract, notwithstanding that it was partly signed. The lack of parental signature, as required by the agreement and by law, coupled with the onerous and one-sided terms of the agreement, renders it voidable at the claimant's election. More so, it has been established at this hearing that the contract was for the benefit of both parties to the contract. On ratification, the tribunal is not persuaded that the claimant ratified the agreement upon attaining the age of majority. Continued performance and receipt of royalties without independent legal advice and while still under the respondent's financial control do not amount to a free and informed ratification. I agree with the claimant that under the child rights law, there cannot be ratification by conduct, and such ratification, if any, must be clear, intentional, and with express communication. The lack of communication on ratification defeats the respondent's argument. The respondent also could have taken further steps, if indeed it wanted to rely on the ratification argument, to seek or to enforce that the claimant ratifies the agreement immediately upon attaining the age of 18, but the respondent failed to do so. On repudiation and consequences, the claimant validly repudiated the agreement within a reasonable time after attaining the age of maturity. She is therefore discharged from all future obligations. The respondent may not enforce exclusivity or copyright claims under the repudiated agreement. The subsequent notice of repudiation at age 19, in the tribunal's view, was timely and effective and does not amount to any estoppel. On the respondent's claim of good faith through trust and investment, while such measures may demonstrate some financial stewardship or responsibility on the part of the respondent, they cannot cure the fundamental defect of entering into a contract with a minor without parental consent, nor do they negate the claimant's right to repudiate the contract. On copyright in the musical work Gyration, the claimant is the author and first owner of the composition. Any purported assignment of master rights under the agreement fails for lack of capacity and consent and is therefore voidable. By valid repudiation, all rights reverted to the claimant upon service of the notice of repudiation. Therefore, the rights to gyration were inherently vested in the claimant at the time of creation of the record. The respondent's assertion of ownership of the sound recording cannot be sustained. I therefore award, the tribunal declares the recording, management, and exploitation agreement of 15 April 2020 voidable and validly repudiated by the claimant. All intellectual property rights, including rights in the composition and sound recording of gyration, reverts to the claimant forthwith. The respondent is restrained from further exploiting or licensing the claimant's works, likeness, or performances. The parties shall appoint an independent auditor who shall account for royalties and revenues, with the claimant entitled to an equitable share in line with best industry practices. Each party shall bear its own costs of this arbitration. All other claims not addressed are hereby dismissed. This is the award of the tribunal. Okay, so what do we do now? Q&A? What do I know? I want to thank the tribunal for the considered decision.
So please put your hands together for our arbitrator and for our counsel. So quickly we'll be moving on to the arbitrator is going to give a short review of the counsel and their performance in the arbitration, and then we'll move over to the handing over of the awards to the winners. Thank you.
Okay. Thank you. To be honest, it's not really a review of the counsel and their performance. I think they were excellent. You know, given the facts of the case, I think they both did well. You know, the facts, as far as I saw it, were more in favor of the claimant. And having said that, even though the facts were more in favor of the claimant, I think the respondent did a fantastic job of trying to convince the tribunal of why the case should have been on their side and why the case should have gone in their favor. But, you know, there are a few points I wanted to point out. At the beginning, somebody on the claimant's team had mentioned and said arbitration is a win-win situation, or we're here to have an amicable resolution. Unfortunately, it's not. Arbitration, what he described is mediation. Mediation is where you have a win-win. Arbitration is not win-win. It is one party wins, one party loses, the same way you would have in court. The only difference is that it's faster, it's more efficient. You know, you're not going to be spending, as Tokpa had said earlier, you're not going to be spending 5 years in court trying to reach a solution. There's also the time value of money. Obviously, we all know what that means. You're not going to waste all your time trying to get a decision that you could have gotten today and get it like 10 years later. So that's the benefit of arbitration. And if you also notice, another thing that makes it fast is we took away all the objections that we lawyers typically bring to court. I'm objecting on this document. I want to tender a document, let's label it XYZ, and we spend hours in court trying to do that. All that is taken away, you know, so that way we can face the crux of the matter. Another point is, in an arbitration, the arbitrator wants to hear from the witness. If you noticed, one of the parties was trying to say, no, he should only answer what I ask him, he should only do this. And I was like, no, actually, because you want to reach a fair decision, not necessarily a win-win decision. You want to reach the right decision, so you need to hear exactly what happened in that case from the witness. So those are some of the things that I have observed. A few other things that may not have happened in real life. One of them is the late filings and all the things that happened. Somebody had filed late, somebody filed an unsigned document. Really, even if that had happened, what the other party will do is to ask for significant cost. Now, while arbitration is effective, it is fast, it is, you know, all these good things that we say about it, it is also expensive. It's a very expensive procedure. And one of the things that drives the cost, drives it or makes it expensive is the cost that will be awarded. So in that instance, where a party is, you know, coming back and forth and filing something late and not filing an unsigned document, what it will ask for will not be cost of. Sometimes when I go to court, for instance, somebody's asking for a cost of 50,000 naira. I've never heard that in arbitration. When people ask for cost in arbitration, they ask for their hourly, the time that they've spent per hour on that matter. So there will be like an itemized schedule. If I spent 10 hours preparing for an objection that you raised, that I raised because you were incompetent, I am going to bill you 10 hours. For context, for instance, some people bill in dollars. Some people will tell you that their time is $600 per hour. If my time is $600 per hour and I've spent 10 hours of my time trying to address an objection, I'm going to bill you $6,000 per hour. So whatever it is, it's not going to be a small amount of money. So the reason why that is so is that it serves as a deterrent. So that you know for sure that you're not going to bring any frivolous objection to arbitration. You're not going to waste anybody's time. If we come on the day of the hearing and you are not ready to go on, they will bill you 3 months of preparation time. If you're calculating this at $600 per hour, you already know what that means. They will bill you 3 months of preparation time, bill you all the time they spend that day, across all the 3 lawyers that came, you're going to pay for it. So this is the reason why people are typically efficient in arbitration and there's no time wasting, there's no dilly-dallying. So one of the things that neither party did in this arbitration was to ask for cost, which again, I found it quite curious. Because in arbitration, costs follow the event, and so the claimant, because you have won this case, you are automatically entitled to costs. But if you don't ask for it, you're not going to get it. So the kind of cost that the claimants, in your submissions, okay, in your written submissions, okay. So, but you didn't itemize. So the claimants has just told me that they've asked for costs. But what they would typically do is to itemize. It's not just to say, give us the cost. You have to itemize it. We paid our lawyers $50,000. We paid arbitrator $30,000. We paid this, we paid that. Give us every single thing that we have spent to come here, and you will typically get that cost back. The respondents, on the other hand, because of all this, their complaints about filing late, they could have also asked for costs, and then we'll find a way to set it off. But the point is that although it is an expensive procedure, if you do win the case, you will recoup your money back. So that's the advantage, and one of the things that we don't get in court. The costs that they give in court are usually quite minimal. So those are some of the things that I noticed here that I thought to bring to everyone's attention. But all in all, I think the council, I think you guys did very well. Well done. Congratulations to both of you. Thank you very much.
So counsel, you get up, we take a picture with the arbitrator, and then we move on to the award session. Yeah, so a picture first, then the awards.
Good afternoon, everyone. How are you all doing? All right, so as the arbitrator stated, the claimant won the case. I don't know if everyone heard. So the claimant won the case and the respondent lost. It doesn't mean that the team lost because they did a great job. So we'll be recognizing the respondent's counsel for their work and their efforts in representing their client. All right, so please come forward.
Confusion. All
right, so first we recognize Mr. Franklin Eze.
I'm really skinny though, why you don't pay me on?
Alright, so Mr. Okena Onyelu, he was actually the lead counsel.
See the money they day for you, baby. Come on, you dey call on my name, I go call on you, baby. Come on. Energy.
All right, so the last but not the least, Rukayat Bakare.
Come love on me, girl, I'm ready. Big ways and I know me, you know. Diamonds on me, you shot, no. Two girls on me, we come for the fun.
All right, thank you all. All right, so there's also a cash prize for the second team. Right, so the respondent team gets 300,000 naira.
I love what you do, you know I'm on a mission. I know your body, oh bad girl, cause it's confusion. What am I family live? Oh, condition. I can't get enough. If you give me job, it's so very cold, girl, I'm in love. I'm really skinny though, why you don't pay me on? I want to propose it. Or over the movie, I'm really living something good.
So we'll move on quickly to calling the sponsors of the award for the claimants, Zeta Oracle. Zeta Oracle is a legal and business management firm focused on providing services to individuals and businesses in the creative industry, music, fashion, film, and more. The mission of Zeta Oracle is to provide comprehensive legal and business management support while fostering a profitable and sustainable creative economy. Please put your hands together as I welcome Victor Ekpo, a senior legal and business manager at Zeta Oracle, and Dr. Ian Lawal, founder of Africa Creative Markets. Please put your hands together for the award.
Good afternoon, everyone. Congratulations to the claimant and sorry, what's the name? Bruno. Okay, sorry, this surname, Bruno. Please, congratulations.
Energy, baby, big energy. Give me ginger, no show me messy. Come love on me, girl, I'm ready. Big ways and I know me, you know. Diamonds on me, you shot, no. Two girls on me, we come for the fun.
All right. First of all, I want to say, Bumi came last year to GCLS and she was very, very eager to become an entertainment lawyer. She wanted to transition from litigation to entertainment. So I'm very proud to present this award to you. Olubumi Apantaku, congratulations.
I love what you do, you know I'm on a mission. I I know your body, oh bad girl, cause the confusion. Put in my family, little, oh, condition.
All right, and I would like to present this to Adewale Oladimeji on behalf of the Global Creative Legal Summit. A round of applause.
I deserve the love, you know, no so mommy. I'm all the feel I'm jara. When you don't, they want me, I'm just bomb me. I'm all go pull up jara. I'm all don't they take the things you want. I'm all the one go as man now. I just want you tonight.
I can't get enough. If you give me job, it's all very calm. I'm in love.
Okay. So the claimant team, the winners, they go home with the cash prize of 600,000 naira. Clap now.
I was built to be the best, number one and nothing less. Lead me to my destiny. I have waited patiently. I have vision, though I believe. I know I can count on me. So stand up for the champions, for the champions. Stand up, stand up, stand up for the champions, for the champions. Stand up for the champions, for the champions. Stand up, stand up, stand up for the champions, for the champions. Stand up, stand up, stand up, stand up.
Please put your hands together for our sponsors and for our councils. Put your hands together for them. You can tell that the organizers of this event actually value creative conversations and value supporting people who participate in moving the frontier of creative business in Africa forward. We're then going to be moving forward to giving awards for our debaters. So, our debaters still here? Our debaters still here? Please put your hands together for our debaters. So to our sponsors, the sponsors for the awards for the debaters is SeedFi. SeedFi is a data and digital lending company focused on financial growth and empowerment, helping individuals build credit history and gain financial literacy. They are also the sponsors of our legal booth for this year's GCLS. Please put your hands together for SeedFi. We're going to be welcoming on stage Pelumi Ali, the founder of SeedFi. Please put your hands together for Pelumi Ali. Please put your hands together for Pelumi Ali. We're then going to welcome on stage Shalom Chuk Sunwoko. Please put your hands together for Shalom Chuk Sunwoko. She's the Chief Operations Officer for SeedFi. So the hackathon starts in 2 minutes. All debaters, please come on stage. If you participated in the debate, please come on stage. Please put your hands together for the debaters as they come on stage. So I'll be calling out the awards in order, and then you come, take a picture with your award, and then you proceed. Paul Olatunji is the second runner. Please put your hands together for Paul Olatunji. Our first runner-up, Vera Anako. Please put your hands together for Vera Anako. She has a cash prize too. So please put your hands together for our sponsors, Sept and for Vera Anako. And the winner, and for the first position, Richard Uyok. Please put your hands together for Richard Uyok. Please put your hands together for our sponsor, Sept, and for the winner, Richard Uyok.
Destiny, I have waited patiently. I have vision, oh I believe. I know I can count on me. So stand up for the champions, for the champions. Stand up, stand up, stand up for the champions, for the
So, we're moving to the other hall. So if you're here for GCLS, we're moving to Sahara Hall. Please, we have people giving you directions. They're waving their hands. Please follow them. We'll continue with the panels and the workshop in Sahara Hall. The hackathon holds here.